Khetri High School. As such, the petitioner is directed to take steps for service of notice upon respond number 7 by speed post or by usual process with AD. Oh no, speed post with AD or by usual process. Um, the full stop. The petitioner, the counsel for the petitioner also prays that he be allowed to bring on record certain documents which had come to his knowledge after this writ petition is filed. Prayer is allowed. List this matter on 15th of July.
Much okay. Well, the name of Liasa may be shown in the call.
Okay. It is further, registry is further directed to reflect the name of GA Assam in the cause list. Mr. Goswami, you are waiting for which matter? You don't have to wait. Which matter? Outcome? 7 to deduction. 7. Okay, Mr. Goswami, I'll take up your matter. Okay. Otherwise, I was ready to take up. Yes, Mr. Barbia?
May I please your lordship, lordship kindly pass over the matter for the time being. For the time being,
For the time being? Okay. Yes, Mr. Goswami. I, 7. Yes.
This is
On the time being.
this
Yes.
is about a batch of home guards initially appointed as special police officer, both under the Home Guards Act as well as in the Assam Police.
They were appointed as home guards. Later on, they were
Appointed again as
appointed again.
again under the Police Act, Assam Police. So they were basically put when the riots were taking place in the BGC area. And they did a very good job and it was appreciated. Now, the problem is below 5,000 posts were vacant, they were sought to be recruited. We said that we were formally appointed under a statute. We have served for so long. You regularize us and then do whatever you like. So that is how it was there. Then they were removed.
Removed.
No? And
On what basis? Contractual basis or removed?
no, because
No reason.
yes. And therefore we are challenging that. And while admitting, my lord, your lordships were pleased to keep the 43 number of posts vacant so far this petitioner set aside. Therefore, your lordship will have to hear this matter for a while
Acha.
and fix a date whenever it is convenient to your lordship. I think it
Pleadings are complete.
should be complete, I think.
Yes, Mr.
That's fine.
Borpuchari.
I know.
Pleadings are, there are so many affidavits I can see. At the bar that pleadings are complete. On the last occasion only it was stated. So, okay, we will take up for admission hearing then on a subsequent date. It will go after vacation or before?
Your lordship, please.
After
Whatever.
vacation, man. It will.
Okay. Heard Mr. P.K. Goswami, Learned Senior Counsel, assisted by Mr. J.B. Chaudhary, Learned Counsel for the petitioner, and Mr. T. Borpujari, you are appearing for whom?
R. Borpuzai.
I always make it T. There are 10 respondents.
I am appearing, my lord, for the respondent number 9, my lord.
Only 9.
Yes, my lord.
Mr. R. Borpujari appears for respondent number 9, and Mr. Dhar appears for respondent number
All except 9.
all. Mr. R. Dhar appears for the respondents number 1, 2, 3, 4, 5, 6, 7, 8, and 10. Oh, no. 1 to 8 and 10 to 16.
10 to 16, my lord.
It is noticed that the pleadings are complete in this case, and a prayer is made for taking up as in the admission hearing for admission hearing after the vacation. As such, list this matter on 16th of July, and an endeavor will be made on that day for disposing of this matter.
15th July. No
In the
problem.
meantime, my lord, the finance department may file our affidavit, my lord. We will serve.
Or you have not filed. Mr. R. Bor Pujari further submits that in the meantime, they will file the affidavit in opposition.
Right.
Prayer is allowed. Hmm?
Blank.
Yes, Mr. Bose.
I'm so obliged.
Hmm.
My lord, it is a my lord, effective case, my lord.
Hmm.
Petitioner are husband, my lord.
Can be taken up.
Yes, my lord.
Pleadings are there.
Yes, my lord.
Okay.
Petitioner, my lord.
Yes, Miss Kotoki, you are appearing for all.
I'm appearing for Animal Husbandry and Veterinary Department, Lordship. Finance OM, Finance Department, they have challenged the OM actually, that completion of, without completion of 1 year service in the department, he is not
Without?
completing the 1 year service in the department, the person is, the deceased family is not entitled for pension, Lordship, completion of
He
pension.
has not completed one
He has
year of
not
service.
completed 1 year of service.
Mr.
very
Borpujari,
unfortunate,
Yes,
Lordship.
but
you have,
here-
I think affidavits are filed.
No, my lord, the finance department is required to file our affidavit because, my lord, a clause 5.3 of an office memorandum
Hmm.
issued by the finance department has been put to challenge.
Hmm.
So we need to traverse that, my lord. I am praying for, my lord, 3 weeks time, my lord. I have to reconstruct my file.
Where is that 1 year requirement of
But
continuous?
here in this case, my lord, in the my lord, compassionate appointment, my lord, there was no time limit, my lord. If today, my lord, appointed tomorrow dies, my lord, compassionate appointment is eligible. But they substituted this compassionate appointment with a compassionate family pension, my lord. Where there is a rider, my lord, the my lord, this employee should have completed 1 year of service when he died, my lord. But here, my lord, petitioner before your lordship, my lord, completed his, my lord, diploma in veterinary field assistant, my lord, in the year 1996, my lord. And there was a, my lord, condition, he could not, my lord, appoint any other place or department, my lord. He has to, my lord, serve in the department whenever he is called for to serve as a veterinary field assistant at least 12 years. My lord. There was agreement with the department, my lord. Nevertheless, my lord, after a long delay, my lord, fighting various cases, my lord, from 1996 to 2019, my lord, he was just appointed. That is a veterinary field assistant. Immediately thereafter, he died.
Okay, we will look into, I didn't understand fully.
It
So we
appears,
will look
my lord,
into.
at page number 26 of the writ petition,
Huh.
my lord, that clause 5.3.
Huh.
Now, that clause 5.3 is a part of the notification regarding scheme for compassionate family pension. Now, my lord,
So either one will be appointed as a compassionate appointment
The-
or he will be given monetary compensation.
No, lord.
uh,
Now,
the-
compulsory appointment totally abolished.
Huh, it's gone after 26,
so there,
ma'am.
there is a-
25.
Yes, my lord, there is a rider that the government servant must complete minimum 1 year of continuous service.
But
Now-
from his argument, it seems that he has completed number of years of service.
No, he was, my lord, a trainee under this department, my lord.
Acha, acha.
And why, my lord, he is bound to serve in the department at least 12 years, my lord. But they are, my lord, they did not appoint this husband of the petitioner immediately, my lord. He, after long delay, my lord, he was appointed.
He was working as what for 12 years?
Field assistant, my lord. And now, my lord, in the compassionate appointment, they substituted, there is a judgment also in this regard. There was a compassionate appointment was substituted by the compassionate family pension.
Mm.
My first, my lord, argument would be before your lordship, in the compassionate appointment, there was a time limit, my lord.
There was no time limit.
Time limit. Anybody appointed immediately died.
So that 1 year service is not required.
Not required, my lord. But
Okay, we will see what.
That is a part of clause 5.3. That is what is precisely put to challenge herein, my lord.
and my lord,
So you file an
Yes,
affidavit.
my lord, we need to traverse, my lord.
the legal point is involved, my lord. They have to show, my lord, there is a judgment I have, my lord. There is a classification they have made, my lord. My argument is that, my lord, it is unconstitutional, my lord. Within a similar group of persons, they have classified, my lord. All will get family pension, but I will not get, I have not completed 1 year, my lord. Is it reasonable, my lord, and what they will, my lord, get, my lord, state, my lord, if I would have completed 1 year, my lord.
But then that is that reasonable
this is the-
classification is there.
This is the, my lord, law point involved, my lord, whether this kind of, my lord, classification within the same class of people is permissible, my lord. And what is the goal involved, my lord? They have to satisfy your lordship, my lord. What they will be, how they
There will be there is a reason to that.
Yes, ma'am.
So okay, we will see whether its classification is reasonable or not.
This kind of.
Mr. R. Yes, Mr. R. Bor Pujari, learned counsel for the finance department, submits that
State will be, my lord.
submits that he be allowed some time to file his affidavit in opposition. Prayer is allowed. List this matter when?
My lordship will kindly accommodate me for 3 weeks, my lord, because I.
3 weeks, so it will go after vacation. List this
I
matter
have
on
to reconstruct my file.
17th of July.
I will be seeking his help. my
Too
lord.
late, my lord, 2021, my lord, matter.
21 matter, Mr. Bapujari.
My lord, it can be.
Any day, my lord, before vacation. my lord.
Okay,
Before
list this
vacation
matter on
also.
19th of June, Friday.
My lord, 19th of June, yes, my lord.
19th.
I'm so obliged.
Huh. Even if you cannot file, bring the instructions, okay, we can
My lord,
dispose it.
I'll be seeking a copy of the writ petition.
Acha,
from my
call-
colleague.
give a copy
I have
of
to
the writ
reconstruct
petition.
my file, my lord. I'm fairly
Okay?
submitting.
Or I'll have to write down in the order, not
No,
required, you
not
give a
required,
copy.
my lord. He will.
I'm from the veterinary department.
Give her a copy as well, huh? 2 copies. Give. Don't be so reluctant.
My name will be recorded.
Yes, Miss Kotoki, Miss S. Kotoki,
MM.
MM Kotoki, appears for the veterinary and animal husbandry department.
Obliged.
And so.
Hmm.
Lord, the petitioner was retired from service in the year 2021, my lord. At the time of the retirement, my lord, there was some recovery from his retirement.
What happened? He retired in 2021 and
21.
thereafter?
At the time of the retirement, my lord, a recovery was made from his retirement benefit, my lord.
Why recovery?
Due to wrong fixation, my lord, that is kindly see page number 21, my lord. Exercise.
Yes, respondent side is represented. Pleadings are complete, it is said.
Oh, my lord.
Union of India, CGC has to come. SK Medhi is there.
Mr. UK Goswami has filed affidavit in opposition.
Okay, you somehow inform him or Mr. Dhar? Can you inform the CGC? Who is the counsel you said?
UK Goswami, Mr. UK Goswami. Okay, I will try to.
Just try to tell him. I'll take it up after some time when he comes.
Some of
Okay.
it is because some other matters are there.
Acha, no, otherwise, in the absence of the counsel, and if he comes and says, no, he is not prepared, he has to given some time, then that will be a waste of time of this court. So we wait for some time, he'll come. Or if you have some other matter, go and come back.
Nine.
9, no, and 1 appears. None appears on call for the petitioner. List this matter again on 17th of June. Hmm? Yes, Miss Kanungo?
Ma'am, please, your lordship.
Hmm.
Lordship, in the meantime, pleadings, they have filed their affidavit and we also filed our reply.
Pleadings are complete, but on the last occasion, they were supposed to get some instructions. Matter is adjourned by 3 on the prayer of Madhuchanda Bhattacharya. Huh.
Actually, lordship, several round of litigations in the year 1998, petitioner was, I'm giving the brief, petitioner was dismissed from service. Because of one criminal case, 376 was their moral turpitude, lordship. In the meantime, he served his sentence. Thereafter, lordship, in the meantime, he approached this honorable court for challenging the dismissal order. When it came to division bench remanded the matter the disciplinary authority because there was some violation of Rule 9. And for disciplinary authority, petitioner filed an appeal, lordship. That was rejected. And challenging that order, petitioner approached this honorable court. This honorable court dismissed, the single judge dismissed the matter. Then again, we went to division bench. In the division bench, lordship, we prayed for compassionate gratuity, pension, whatever may be, under Rule 24 of the Assam pension rules, lordship. And on on that day, the division bench, honorable division bench asked us to file appropriate petition before the appropriate forum because in earlier writ petition there wasn't any prayer for compassionate gratuity, pension, whatever, what can be done for him, lordship. So thereafter we filed this writ petition before this honorable court. At this stage, our prayer is that Lordship, since prior to the incident, petitioner served 13 years, Lordship. So at this stage, now he's 61, 62 like this. So we are praying for some compassionate pension, gratuity, whatever can be.
And in the meantime, he served his sentence also.
Served
Sentence was how?
5 years, RI for 5 years.
5 years.
He has served, Lordship. Now, as per rule. 24
After serving his sentence, he proceeded with his inquiry. He did all this.
Yes, yes, Lordship. He served, in the meantime, he served this sentence, Lordship.
Acha, Miss Bhattacharya, in fact, some instructions were sought for. What instructions were sought for?
No.
Pensions from the pension department.
In regard that I don't
Hmm.
pay. Rule 24 may kindly be seen, Lordship.
Hmm.
As per Rule 24, there is a scope for the dismissed government employees, Lordship.
Acha, one
For
second.
some kind of help for their survival.
Rule 24 of the
Of
pension.
But Rule 24, we have mentioned there in paragraph 7, Lordship,
Hmm.
that no pension may be granted to an officer dismissed or removed for misconduct, insolvency, or inefficiency. But to the officer so dismissed or removed, compassionate allowance may be granted when he is deserving of special consideration.
Yes, we are seeking that. Against that affidavit, we have filed our reply also, Lordship. Lordship may kindly see Rule 24. There is a
There are no
scope that-
pension rules. Hemanda.
Division bench, that is why. said
Amanda.
that approves the appropriate-
Okay,
Pension
Lordship,
rules.
then I will obtain one instruction whether this can be, because all the instructions are of 2024, Lordship, here.
Acha.
Honorable
Hmm.
Lordship, honorable division bench was satisfied. That's why the
I think
division
after-
asked us to approach the appropriate forum, because they were not in a position, because there wasn't any prayer for this in earlier.
So all you are praying is the compassionate.
His survival, Lordship, at this stage, because he is now 61, 62 years old. This is the only hope he has for his survival.
Special consideration, who will grant Lordship, that also I will appraise your Lordship.
Rule 24 may kindly be seen. If,
Hmm.
if Learned Council want to take instruction, I don't have any objection for that. But there is a scope.
24.
24.
Hmm.
Misconduct or
Hmm.
inefficiency. We are not claiming any pension, Lordship. Only just something so that he can survive at this stage. Because he has served his sentence, he has suffered a lot, Lordship.
So whether the only thing should be shown is whether he deserves that consideration.
The special consideration whether
He had served for so many years before that, right?
13 years, it is reflected in the order of.
What is the offense about?
That was 376, Lord, IPC.
Oh, 376.
Moral turpitude was there, misconduct was there. But for that, he has served his sentence, Lordship, RI for 5 years.
So, Ms. Bhattacharya, why deprive him?
Lordship,
Yes,
that's
see?
why, because all the, who will grant and under what circumstances it can be granted on specific, these things, Lordship, I shall obtain instruction and appraise your Lordship.
That may be reflected in the order, Lordship, what.
Because
to
all
take.
Acha, who will grant what is
Yes, Lordship.
consideration?
Yes.
It is not provided in this
Nothing
one.
is there, under special consideration.
Hmm.
This is there. So who will consider? This also has to be Lordship appraised.
Has to be seen by the director of pension, I believe.
No. Lordship, first director of pension, everything has to be processed from the department. Then the director of pension. It is the last thing only, they only issue. Director of pension is also not here, Lordship, because it is the Accountant General Office, Lordship. So here,
Okay, heard Mr. S. Kanungo, learned counsel for the petitioner, and Ms. M. Bhattacharya, learned additional senior government advocate. In this petition, the petitioner has prayed for a compensation, has prayed for compassionate allowance, compassionate allowances under Rule 24 of the Assam Service Pension Rules 1969. it is stated by the learned counsel that the petitioner, after serving for 13 years in the Department of
Assam Police.
Assam Police, in the Department of Assam Police, serving for 13 years under the Assam Police, Assam Police was charged with a criminal offense, and that in conclusion of the trial, he was convicted and he served his sentence. And and he was removed from his services in the year
In 98, Lordship.
in the year 1998. However, after that, he has prayed for other reliefs, and this honorable court had allowed, right, those gratuity and all those, what? No.
Oh, nothing, nothing is.
Whether the petitioner made a prayer, Lordship, any representation or nothing?
No, like, yeah, he was removed from service.
Nothing.
Now he has filed this petition for his compensatory allowance. Ms. Bhattacharya,
Compensatory allowance, this is under special, Lordship, special compassionate allowance.
Not
compassionate allowance,
compensatory. And one
compassion.
more thing, they have not made any representation, ki grant Lordship. So nothing is there. Directly they have come before the court. They have to make prayer, Lordship.
Okay, that I will direct, but who will pay, who will consider his case?
This is
Bring that
different,
instruction.
Lordship. They also have to pray because the authorities, they are not knowing these things. Without a prayer,
Acha, Ms. Bhattacharya, senior so-and-so had submits that before granting the compassionate allowances, the requirement is that his case should be a deserving case, and consideration has to be seen by the department concerned. As such, she wants some time to get the instructions to the said facts. Prayer is allowed. List this matter when?
23rd, Lordship.
23rd of June.
Video files.
Oblige, your Lordship.
8.
Oh, sorry. Oversight the matter, I could not attend the court.
Oh, it's okay.
Oh,
You are
can
for
it
the
be
central government.
Any other
Day.
day, Malad?
Oh, he did not prepare.
The file is gone.
Okay. Mr. U.K. Goswami, learned CGC.
Malad.
Learned CGC prays for some time to go through the case. Prayer is allowed. List this matter on when, what date?
Any day, Malad.
Matter
Yeah,
on?
convenient to your lordship, Malad.
On, no, every day is convenient, no issues. Only your convenience will
Next
matter.
week, any day, Malad.
What? 18th of June, Thursday.
Malad.
Next to next Thursday.
Malad. Can it be in a,
15 I'm not there, Mala.
Last week, I don't want to
Yes,
burden
yes.
this court with
You can have it
admission.
16, my lord, if convenient, 15.
16th,
16.
Malad.
Tuesday,
Well.
16th of June.
We have covered matter otherwise because the recovery without notice, my lord.
Huh.
And to have a group C employee cannot happen, my lord.
Now, I've seen few judgments, recovery for no fault of the petitioner can also be not done. Okay, let him go through.
Malad.
Mm.
The order is 8-4, madam.
8-4.
PTC authority is only sitting that malab suspension period malab regularized malab.
So the instructions were in place, it is said on the on this occasion.
What has happened in this case is that the director, if lordship sees the instruction, the director has forwarded the financial proposal to the secretariat level, Lordship. From the directorate level, it has gone to the secretariat level of the BTC. Now, what has happened is that finance being a transfer is not being a transfer subject, Lordship. There needs to be approval from the state government.
Mm.
Therefore, Lordship, I'm praying for some time to get the instruction whether that from the secretariat level, the finance has been accorded or not. That instruction I did not have. However, Lordship, in accordance with the order of 8/4/25/26, Lordship, the director has forwarded it to the secretary. If Lordship.
But you're yet to get the finances approval.
Lordship.
This is in relation to area of salaries means after retirement he has,
During suspension, he died.
oh, during suspension he died.
Right, ma'am.
Okay.
No
With
DP
reference to
has been
no, no.
initiated. No DP departmental proceeding has been initiated.
Has started.
That's why, my lord, on 18th for this honorable directive. to
So
take a
in that
step
case, what happened? He will be given the area salary for the entire suspension period.
No, my lord,
Subsistence allowance,
75%.
75%
75
of the salary.
salary.
Mm-hmm.
But it is not paid, my lord, till date, my lord. So far as pension is concerned, my lord, already proposal submitted before the deputy inspector of schools, my lord.
Mm.
But he has not forwarded, my lord.
No,
No
Lord-
step has been
Lordship,
taken.
that is incorrect. The deputy inspector of school it goes on a process, Lordship. The deputy inspector of schools forwards it to the director, and the director then forwards it to the secretariat level. And thereafter, the secretariat level goes for the approval from the state government, Your
No,
Lordship.
that is in context of the pension.
Pension.
Lordship.
And what about his area
The area salary,
subsistence?
the area salary, Lordship. That instruction which I have placed is in connection with the area salary, perhaps, Lordship.
Mm.
Suspended.
Yes, sir.
Area subsistence allowance
Area salary, Lordship. 75%.
and pension also, the same process.
Pension is separate.
Separate process.
The husband died on, my lord, 1/4/2024, my lord.
Okay, right, heard Mr. K.R. Patgiri, learned counsel for the petitioner, and Mr.
NR Sharma, Lordship.
N.R. Sharma, learned standing counsel for the BTC. The learned counsel for the BTC submits that as far as the prayer of area subsistence allowance is concerned, the necessary proposal was forwarded by the inspector of schools to the director of
Education BTC, Lordship.
Director of Education BTC, who in turn had forwarded the proposal to the Secretary of the BTC,
Finance, Lordship. Secretary, Finance Department, BTC, Lordship.
Secretary Finance Department, forwarded to the Secretary Finance Department of the BTC for the approval, for the necessary approval. That is, the learned counsel submits that is awaited. As such, that is awaited.
Lordship.
As such, he prays for some further time so that the updated instructions can be placed before this court. Prayer is allowed. List this matter on when?
Can it
Can
be after vacation, Lordship?
after vacation. List this matter on
Pension proposal may be sent to the
provisional pension. Are you giving him?
provisional pension.
I will take instructions in that as well, Your Lordship.
You try to. I'll fix it after vacation, but in the meantime, you try for the
Absolutely.
list this matter on 15th of July, 2026. In the meantime, the learned counsel for the BTC. In the meantime, there is no bar for the BTC authorities. In the meantime, since there is no bar to the BTC authorities to give the provisional pension to the petitioner, the said process be undertaken by the appropriate authorities.
Date may be fixed.
Mhm.
15th.
During the pendency of this petition. List this matter on 15th of, accordingly, list this matter on 15th of July. Mr. Roy? You keeping good health, I believe? Yes, everything is fine? What is this matter? Can it be taken up?
The petitioner was a constable in the APBN.
Yeah, respondent side is ready.
My lord, this is a dismissal from service.
Uh-huh.
We have filed our affidavits, my lord.
So ready?
We have,
Pleading is completed.
Ah.
pleading is complete, but my lord, this is a dismissal from service. Without record, my lord, we cannot proceed, my lord. Dismissal from service, my lord has to look into the, my lord, proceeding, my lord. That
Your
is-
affidavits will cover.
No, my lord.
They want the record.
Records
The record is required.
required, my lord.
Because
Okay.
there is before dismissal, lordship, the prosecution did not examine the informant who lodged the FIR and petitioner was not asked to stay outside. He was not allowed to cross-examine the witnesses.
We know these things will come. That is why, my lord, I said.
So Rule 9 violated.
No, my lord, that is why record will.
Okay.
That
Heard
is
Mr.
there.
S.P. Roy, learned counsel for the petitioner, assisted by Miss V.
Vaishali Rai,
Uh,
his granddaughter,
Vaishali, your daughter,
granddaughter.
granddaughter. Very nice. Welcome to this profession. So and so, assisting the counsel. Mr. Dhar, R. Dhar, learned standing counsel for
No, my lord.
learned government advocate,
Education system.
submits that the records would be necessary for the proper adjudication of this case, and as such has prayed for some time to place the same before this court. Prayer is allowed. List this matter after vacation.
After vacation. And
List
one
this
thing, my lord.
matter on 17th of July.
My lord, they haven't filed their reply also to our affidavit.
Now,
Not
I'll file
required.
the meantime. I'll file my affidavit in it.
List this matter on 17th of July. 17th July for placing of records. Further, Mr. Roy further, Mr. Roy submits that he will also file the affidavit in reply if required in the meantime. Prayers are allowed. List this matter accordingly on 17th of July.
Like,
Yes, Mr. Padgiri again.
Lordship, we have filed an application, Lordship, for striking of our name as restaurant numbers 13 to 17, Lordship.
As respondents. Why? Not necessary party.
Lordship, they have been promoted to the post of.
Oh, they are the private respondents.
I get initially, my lord, they preferred I am, my lord, for improvement, my lord. And thereafter now, my lord, stating that, my lord.
Entire exercise gone for nothing. Now again striking off.
My lord.
Lordship, because we are
Yes.
17 to 13 to 19, Lordship. Now two remains in the fray, Lordship. Respondent number 18 and 19 is still in as statistical assistant, and they will continue to remain in the proceeding.
The others wants to go off.
Lordship,
What do you
because
say?
they are promoted, Lordship.
He has in fact not implemented you as party respondent.
Yep, my lord, private.
No, there is no grievance actually. So it is not necessary for them to get implemented as also. Okay.
And issue regarding, my lord, small issue, my lord, my lord, ad hoc period can be considered for seniority, my lord. And Supreme Court directly equate class to engineering.
Okay, let me dispose of the IA, then we will hear the writ petition.
Dear Lordship, it's not possible because we are not ready.
Affidavit.
It will take a long time, Lordship.
Okay. Acha. Who will be there?
Yeah.
Okay. IA to लिखिबा, हाँ, IA में लिखना. Heard Mr. K.R. Padgiri, learned, heard Mr.
R. Islam.
R. Islam for the applicants and Mr. K.R. Padgiri for the respondents. By this application, by this interlocutory application, the applicants have prayed for striking off their names from the array of respondents, being respondent number 13 to 17 in the connected writ petition. It is stated by the respondents that they were impleaded as party, it is stated by the respondents that they are the private parties who got impleaded themselves in the writ proceedings by filing an IA on an earlier occasion. And now it is stated that they have been promoted from the post of statistical assistant to
the post of CDPO and allied cadre.
to the post of child development project officer and allied cadre. As such, an application is filed for striking them off from the area of respondents. Be that as it may, it is also, it is a settled position of law that the petitioners do not claim relief against the private respondents, and relief is claimed only against the official respondents. As such, the
Respondent number, my lord.
okay. As such, the application is allowed, and the applicants are directed to be struck off from the party of respondents, the registry to do the needful. Oh, what has to be done? You have to file an amended
Then
cost
I
title.
have to file a amended cost
Cost
title
title.
also, my lord.
Huh.
Yeah,
And
yeah,
yes,
my lord.
Mr. Not
maybe
registry, huh? Wo card do. The petitioner is as such directed to amend the cost title of the, file an amended cost title of the, amended cost title, file an amended cost title. And the resultant modification will done in the CIS system by the registry. IA is allowed. In respect of the writ petition,
Lordship,
Ms.
I-
Bhattacharya wants some time.
For main, and for respondency, 82/12.
Okay. Her, in the main writ petition, you write, heard Mr. K.R. Padgiri, learned counsel for the petitioner, and Ms. M. Bhattacharya, learned additionals. Uh-huh.
1 to 7 in the main.
Okay. Learned additional senior government advocate appearing for respond number 1 to 7, and Mr. D. Bora, learned counsel appearing for 8 to 12. 8 to 12. Ms. Bhattacharya submits that she wants some time to go through the instant case and has requested for listing of the matter after the vacation.
Short that, my lord. Part of retirement, my lord, that person.
Sir, before vacation, can it be done? Or before vacation, Ms. Bhattacharya?
I think they have not filed their affidavit also.
No, filed, already filed, already replied, pleading completes, my lord.
No, affidavits
I
are
have
there.
filed, but
There, my-
I have filed, but I just don't know whether private respondents.
I
have
have,
filed.
Yes.
I have to file, Lordship.
Well, you are already out. What do you have to file?
I am out for 13 to 17. 18 and 19 remains.
Okay, and Mr.
R Islam. Lordship.
R. Islam for respond number 18 and 19.
No, Lordship.
18 and 19 have not filed affidavit
No.
after the vacation. Further, the learned counsels for the private respondents have submitted that they need some time to file their affidavits. Accordingly, list this matter on 13th of July, immediately on the reopening.
Obliged.
It can be on 14th, Lordship.
14th of July.
All right.
Yes, Mr. Goswami.
Lordship, in this case, I have to file my affidavit, Lordship. I need some time to file it. Let it come after vacation, I will file it.
Yes, Miss
D. Bora,
D. Bora, learned counsel for
health.
health, submits that she requires some time to file the affidavit in opposition. Prayer is allowed. List this matter on
After the vacation, Lordship.
after the vacation. List this matter on 20th of July, 20.
Lordship. Obliged, Lordship.
Here also affidavit already.
Your ladyship, we are yet to file our affidavit. Ladyship, may kindly list it after vacation.
Lordship, kindly say the petitioner is not getting the salary from 2023. Lordship.
Did not get salary from 93.
No, Lordship.
Raise your voice. I could hear that. Huh?
1/10/2023.
23, he did not get his salary.
From 1/10/2023. Oh, Lordship,
Before that, he was getting.
before that he was getting.
Okay, let them file the.
Current salary may be released. Lordship.
Your ladyship,
he-
If the salary is
Salary
released,
is to be
your
released,
entire
lady.
petition is done.
Finance.
Huh?
Current salary may.
salary.
Current salary.
Lordship.
Sorry, your ladyship. Ladyship, salary is supposed to be released by the finance department, your ladyship.
Was released.
Is to be released.
Is
by
to
the
be
fin-
released. His current salaries.
The salary of the petitioner.
You are for
The KAC, Lordship. on behalf of
KADC.
the JHT.
Finance, you are appearing.
No, you're not.
Acha. Yes, Mr. Borpujari was there. So let them file the affidavit and your current salaries will be paid.
Last time they have also taken time for the filing affidavit.
Finance is not a party here.
Finance. On 27/4, they have taken time for filing affidavit.
But finance is not a party, so how will you get AADC will do it? Okay, heard, Mr.
D. Boregi.
B. Sohain, learned counsel for the petitioner,
But-
and Miss.
Lordship, D.
Shohei.
Boregi.
Uh-huh.
B. Boregi.
Oh, D. Boiragi, yes.
P.
B. P. Boiragi, huh, for the petitioner, and Miss
V. Shohya, ladyship.
B. Shoria,
On behalf
Le-
of Mr. J. Chittian,
Learned Counsel, Standing Counsel for KAADC,
Your Lordship.
for KAAC, KAADC, I think, KAAC, huh? And Mr. Dhar for respondent R. Dhar for respondent number 1. Ms. Shore, Learned Counsel for the KAAC, submits that she wants some time to file her affidavit. It is further submitted that the issue of payment of current salaries to the petitioner is being processed by the is
Yet to be released, is yet to be released, will be released by the finance department, not us.
is in the process of release by the finance department. As in view of,
It should be taken by the concerned authority that is there.
in the meantime, the said salaries be released, if any, by the finance department, as there is no bar. Okay, list this matter on 21st of July.
My lord, after the reply, my lord, the petitioner is out of station. She is CRPF constable. She is going to Maharashtra. Constable will grant us me a week's time, and she's arriving on Saturday tomorrow.
Okay.
Issue is
As
that-
prayed for by Mr. D. Gogoi, Learned Counsel for the petitioner, list this matter on 15th of June.
My lord, 15th June. 15th of June.
On 16th of June, whatever. 16th of June, 2026.
This is an interim.
My lord,
The interim order passed earlier shall continue until the next returnable date. Mr. A.K. Dr. Learned CGC appears for the respondents.
Chief, I am a class 3 employee and I had. super
Affidavits are
negligence-
filed. It seems it is filed.
Yes, Lordship.
Ready?
Your Lordship, the conducting council is on legs. Lordship,
After
could-
some time?
After some time.
2 o'clock.
Or whenever he comes. Eh? Yes, 18. Pleadings complete? No, no affidavits at all. Not required.
Not required, madam.
Not required? Ms. Sharma?
Lordship, an ongoing criminal investigation is pending against him. Lordship, that we have to find out whether it is charge sheeted or not.
It's pending, but other day, but the disposal matter has come, madam.
Doesn't matter his criminal proceeding.
Yes,
We are on with the departmental proceeding, I believe.
Departmental proceeding has exonerated him from.
So he will be reinstated then.
No, I will raise
Reinstated
I'm
already.
waiting for promotion, madam. From the post of, madam, constable to driver constable to, madam, to lance nayak, madam.
Whether there is any bar for his promotion in view of
Well-
the criminal case? No.
I
Right.
have annex one, madam, one office memorandum
Mm,
to by the government of Assam, madam.
mm.
But it is pays, madam, 108, madam.
So there are two matters today.
The other matter has been, madam, disposed of, madam,
Acha.
on, madam, 25/5/26, madam, arising out of the same incident, madam.
Acha.
Except me, madam, all got the benefit, madam.
Oh, why are you left out? Because of criminal case?
Yes, madam. The other day, the other person has got the benefit, madam, on 25/5/26, madam.
Hmm.
Madam, can you see 108, madam?
Oh, this is what you have placed?
Yes,
The
ma'am.
other case?
Yes.
4286.
Yes, madam. He got the promotion from ASI to SI, madam.
In those cases, there were no criminal cases. In this case, there was no criminal case.
Yes, madam, he has a criminal case, madam.
Well, it's written, it is admitted position, there is no criminal case pending before any
But
competent.
criminal case means, madam, no charges has been filed.
Acha,
madam.
acha. It is in the investigation
Yes, madam.
stage. Okay. Same is the case here.
Yes, sir. Sir. Only the-
What is the criminal case about? What
Uh,
charge?
By say extortion, madam, however, the main accused, madam, he got the promotion, madam.
You all had admitted.
No, madam.
Acha.
In one of the defiant proceeding, which was initiated against the lady, madam, the main accused, madam, where the victim says, madam, we are not involved, madam.
Acha. in his statement before
It is,
police
Yes, my lord, in the.
as well as departmental?
Yes, my lord.
Acha, let me see. The documents here, what?
Yes, my lord. Kindly see page 31 is the FIR, my lord.
31. Okay.
This is the FIR.
What is your name?
Kajal Das, my lord.
Kajal Kumar Das, okay.
Yes, my lord. He was the driver, my lord.
He was a constable.
Yes, my lord. Driver constable, my lord. Because of the arrest, my lord, in this case, my lord.
Once again, I have not finished reading. At around 7 p.m. in the evening, they took me. Okay. So that lady police was there,
Yes, my lord.
and these are all unrecognized, unidentified.
Yes, my lord. Now,
Huh. So lady police's name was Dipali Borua.
Dipali Board.
Then what happened?
Now,
This was in 2017.
17.
ये दे दीजिए। जुलाई का है? Imagine. देखिए। उसके बाद ऐसे देख के देखो। So that was in 2017.
Yes, ma'am.
Still investigation is on.
Yes, madam.
Okay, then.
Page 36, madam, he was placed under suspension because of his arrest, madam.
Huh.
Then, madam, he was again, madam, registered into service, page 37. And, madam,
Reinstated after courts or no? After his exoneration in the departmental inquiry?
no, before, madam.
Before.
Before. Page 37, madam.
Wait, where is the suspension or during the
Page
okay.
30 is the suspension order.
Oh, on his application only they had reinstated.
Yes. Now, page 38 is a so-called notice issued to me, madam, on 15th September 2017.
Yes.
Statement of allegation is at page 39.
Then?
Page 41, the victim of Brian Hallow submitted the affidavit before the inquiry officer that we are not involved.
Biren Haloy?
The victim, madam.
This is this is a letter to
the inquiry officer.
So the offense was selling and purchasing of petroleum oil.
Yes.
They were in fact arrested. There was something in between. He was compelled. By following STF, they were not involved in demanding and taking money on account of releasing me. They have no connection. So who has connection then? Why did he file the FIR? Then what happened? On this basis, he was exonerated.
No, madam. Page 45 is the order passed by the disciplinary authority.
45.
Yes.
This is what? Affidavit is what?
Affidavit,
Saying that they are not involved.
yes.
Mhm.
He
Then,
was the driver.
then,
Then 45 is the order passed by the disciplinary authority.
Hmm.
I have been exonerated from the service. I have seen the
so inquiry officer inquired. Then what happened? Srimati Ingtipi, appointed as the inquiry officer, hold an inquiry against Siva driver Kajol Das and Shiva Prasad. Inspector was appointed. He was in judicial custody for some 1 month.
yes.
Okay, then
Still in the 2020, madam, I have been exonerated from the charges, madam. In the year 2023, madam, the government has introduced a scheme, madam, for promotion from the post of constable to lance nayak, page 47.
this is under assured career progression scheme.
Yes.
3 rank promotions from so and so. Then you applied.
Yes, mine have been forwarded by the my organization, page 51. Assam Police Headquarters. But here, madam, page 53. there's
Let
a-
me see 51 furnishing of service particulars. And this is by SP to additional SP to IGP.
in a STL.
Acha. I have the honor to enclose your service particulars of constables. Okay, then
And there's an endorsement of the additional SP STL in page 53. Once when proceeding is pending,
53.
53, where a start has been enclosed by the additional SP STF,
No, what? I didn't get you.
but along with this,
I mean, the ASP, the additional SP has written that progression scheme should be allowed.
out and they send my name,
Huh.
but endorsing that one DP or email court case is pending, page 53.
Where it is written? Kajal Kumar Das. Date of birth, date of appointment, date of promotion, nil, OBC, Hindu, HS pass, where it is?
In the column, my love, 15, my love, says my love, yes.
15. There is no such stipulation, yes, major. 12 years and...
DP oblique court, if any, yes.
Wait, DP, court, departmental proceeding, court, if any. Oh, acha, this is yes. Acha, yes. So DP is on, but DP is finished.
Already,
Maybe the investigation is on,
Yes.
but DP is not on. DP/court. What is court?
Court
Court
case.
case. Court case. If any, if he said yes, this is a wrong information. Because by the time this is sent, the DP was dropped. DP is finished. Even the authority, the departmental authority had agreed with the inquiry officer then. So he was not promoted.
Yes, ma'am. Page 57. All total 21,000, near about 20,000 customers has been promoted to the post of last time. Except me.
Only on the basis of that. So now your prayer is for promotion.
Yes, ma'am. No, I have a one, under prayer, madam, because madam, in the meantime, the MSCP scheme also came into force, madam.
MSCP progression scheme.
Yes.
No.
Because I have not been promoted, madam, in the meantime, so I'm also entitled to the one increment, madam. Because my appointment is of 2011. And 10 years is completed 2020, madam, 21. Then the MSCP should be I'm entitled for the MSCP from 2022.
Well, let them first promote you first, then increment. And what else? This is your case.
When my kindly see, it started my page 95.
Hmm.
The 11th portion is page 97.
Hmm. What is this OM about?
It is being issued in light of the Darban Panchayati Gabi Zanagiri Raman case. Gabi Zanagiri Raman case, madam.
Hmm.
Clause 5, madam, page
Hmm.
97, madam.
It is not. It is also there is no requirement furnishing a separate integrity certificate.
In terms of the judgment of order Supreme Court in the case of India versus so and so, no promotion can be withheld merely on the basis of suspicion or doubt or whether matter is under preliminary investigation has not reached the state of search. So in this case, no search has been filed as yet.
You're sure? Or you want to have the instruction?
Let us have that instruction, Your Ladyship, because whether charge sheet is filed or not, that instruction we do not have.
When counsel says that the investigation is on, no search has been filed. On Monday,
And in fact, my lord, in statement of allegations, while Kajal Chandra Das was posted as STF, he was accompanied with one WSI Dipali Borua of STF Assam Srimantapur. They both were together in the vehicle. And that Dipali Borua, Your Ladyship, who is also named in the FIR as one of the accused, based on that facts revealed in the inquiry report of the departmental proceeding, the disciplinary authority had imposed the penalty of severely reprimanded against WSI Dipali Borua. She has undergone some punishment. Lordship, so.
But as part of this order, she was given the promotion, madam.
But the fact remains whether charge sheet is submitted has not reached the stage of issue of charge sheet, etc. Hmm.
This judgment will clarify everything, madam.
Janki Raman.
Yes.
What is this paragraph?
Paragraph 8.
Or you can bring the instruction by 2 o'clock, Ms. Sharma. Whether
I will
any
try, Your Ladyship. I will
whether
try.
any charge sheet is filed. Right. Or what does Janki Raman say? Just show me the paragraph.
Paragraph 8, 16 and 17.
Paragraph
8.
8. 8 will be the facts. What?
The issue has been framed.
Hmm?
Issue has been framed.
That is seal cover. It will be kept in the seal cover.
But actually come to paragraph 17, madam. What is the
Hmm.
on the day of my consideration promotion, if the no dependent proceeding, no search is being filed, madam, then my promotion cannot be withheld, madam.
Yes, that is a fact. It cannot be withheld. Your charges are also dropped. But then what about criminal case and charge sheet?
Later take instruction.
At 2 o'clock, Ms. Sharma?
Yes, Your Lordship.
But then don't again take time. You call up the person by
Yes.
telephone and then get the
Yes, Your
instruction.
Lordship.
If no charge sheet, then he'll be considered.
Yes, sir.
Then later on you take action.
Yes, Your Lordship.
Right. Okay, at 2 o'clock.
Yeah.
Call up at 2. Yes.
But I'm really sorry, I was on
It's okay. Yes. Why did it got deferred? Because of his absence?
Yeah.
And what about affidavits? Is it filed? It's filed, I
Affidavits are
believe.
exchanged. Otherwise, your lordship, this matter appears to be covered. There were two very similar petitions where two employees of APDCL against whom recovery proceedings had been initiated, even though they are in grade 3, grade 4. We had taken a plea that two grounds, in fact, that the recovery proceedings were initiated before the judgment of Rafiq Masi. And secondly, there was a significant delay in them approaching this honorable court. The other matter, your lordship, has been decided in favor of the petitioner. So perhaps
Even before Rafiq Mashi, I think there was a
there
case,
were some
Burma,
judgments. There were some judgments,
Ram Burma or something.
but specifically to make it complete, I mean, to completely exclude grade 3 and grade 4.
Acha.
So
Okay.
perhaps this matter will also be covered by this judge.
Okay. Rafiq Masi will, this is before Rafiq Mashi.
This initial proceedings, he had retired before Rafiq Masi.
But then no recovery after he retires in a grade
My
3,
lords.
grade 4,
My lord.
for no fault of his.
My lords.
So what is the fact? Just show me.
I was animated in March 2013.
2013.
13. And the
Acha.
recovery was done on March
He superannuated 2013.
2013. Superannuated in 2013.
Then deductions made when?
March 2015.
2015. Then you had made application or something?
Your Honor, my representation is that 2025 I had filed my representation.
Wait. What is this annexure 1?
Annexure 4.
Acha. Annexure 4, yes.
Annexure 4 is the representation. We had mentioned the Rafiq Masi in the
This was made on what date? Delayed. Some delay.
Your Honor, Annexure 2 is the order by which gratuity was collected from me, recovered from me due to the excess period, and the representation was filed in 2025.
So wait, Amanullah Mandal is the petitioner. So Amanullah Mandal may be disbursed a sum of rupees so and so only being the amount of gratuity so and so. An amount of rupees 1 lakh only being overdrawn. Fee and allowances adjusted out of the total gratuity. Amount of debt come return is mentioned above may be credited to SB account of so and so. So they have already deducted the amount of 1,97,000 and paid you the rest of the amount. 2,96,000, but you were supposed to get 4,94,000. Right. So it was already deducted when it was paid. So you made a representation for recovery.
Yes, Your Honor, in April 2025.
April 25. So quite late, after 10 years.
Your Honor, I'm old person, like 72 years old. And been suffering from a lot of mental illness.
Okay. Then the affidavit, what do they say? That they had approached late. That is the only.
Only on the ground of delay and applicability of Rafiq Masi because of the date.
Mashi had come into effect when? February?
December 2014.
2015.
14.
14.
14.
December 2014.
December 18, 2014. 18 December 2014.
15 December.
18 December.
18 December 2014. So he made his application in deductions were made in 2015.
Deductions were made after his retirement to here, retired before Rafiq Masi.
Retired before that. Okay. Heard, Mr.
SS Talukdar.
SS Talukdar, learned counsel for the petitioner, and Mr. KP Pathak, learned standing counsel for
APDCL.
APDCL. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for disbursing an amount of rupees 1,97,832 towards his gratuity, which was deducted by the by the concerned officials in the Assam Electricity Grid Corporation Limited for being for the reason that the said amount was overdrawn by the petitioner. The case of the petitioner is that he was working as a peon.
Bill clerk.
He was working as a bill clerk in the in the building division of BTP ASAB Kokrajhar. And he had continued in the said capacity till the date of his retirement, that is on 15/3/2013. After his retirement, the authorities, while making payment with regard to the gratuity, had deducted an amount of rupees 1,97,832 from the said amount on the ground that it was overdrawn by the petitioner. While order dated 17/3/2015, before the said order, there was another office order dated 19/1/2015 by which it was ordered by the authority concerned that the gratuity amount of the petitioner being rupees 4,94,670 would be paid to him, but subject to adjustment of the outstanding liabilities of rupees 1,97,832.
Before the said order,
being
there was
overdrawal of
another
pay
office order.
and allowances. Where is that? My own voice?
Perhaps.
I don't know. Okay. Against the said deduction, the petitioner has submitted a representation for recovery of the gratuity amount on what date? 25, you said? Date is not there. In the year 2025.
25, March, April 2025.
In the during April 2025. There is no reply to this representation?
Oh, yeah.
Which, however, the learned counsel for the petitioner submits that there was no reply to that, to the said representation. Being aggrieved, the petitioner has approached this court by the aforesaid prayers, with the aforesaid prayers. In the instant proceedings, the respondent have filed their affidavit in opposition, stating inter alia that there was delay. There was enormous delay in making the representation by the petitioner for recovery of his gratuity amount. And further, that the decision of the Honorable Supreme Court passed in State of Madhya Pradesh versus Rafiq Mashi. State of what?
State of Punjab versus Rafiq.
State of Punjab versus Rafiq Mashi. Reported in
2015 4 SCC 334.
2015 4 SCC
334.
334, by which the Honorable Supreme Court had held that the deduction cannot be made from salaries or retirement benefits if for the same there is no fault of the employee, right?
Yes, and for grade 3 and grade 4 employees, it is.
And the same principle was made applicable specially to grade 3 and grade 4 employees. The learned counsel for the respondent submits that in the instant case, the petitioner has retired much before the aforesaid case. Although the deduction was made after the said case was delivered by the Supreme Court. Do you have that, Rafiq Mashi?
Pilots.
Both of you have. Good. Diana? Para. In the case of State of Punjab versus Rafiq Mashi Supra, it is held by the Supreme Court. Which paragraph I forgot?
My lord, paragraph number 18.
18
18.
or 12?
18.
18. Held that it is not possible to postulate all situations of hardship which would govern employees on the issue of recovery where payments have mistakenly been made by the employer in excess of their entitlement. लिख पाए और एक बार बोलें. As such, since it was not possible to see all the situations, the Honorable Supreme Court had categorically held that for no fault of the employee, if any recovery is made, the same was stated to be unfair and bad, and it should be refunded to the employee concerned. It be stated here that even before the decision of Rafiq Mashi Supra, there are decisions by the apex court. Do you have that Verma decision or something?
Have, Your Honor,
It is
Jitendra
referred in
Kumar.
paragraph number 14 of this.
Jitendra Kumar.
14.
14. My lord. Shyam Babu Verma versus.
Shyam Babu Verma, that is what I was searching for. One of such decision was Shyam Babu Verma versus Union of India, reported in 1994 2 SCC 521, wherein it was also held wherein in the facts of the said case that the employee was paid enhanced pay scale from an earlier date then on the completion of 10 years of service. Which was later sought to be recovered from the petitioner in that case. And in the said facts, it was stated by the Supreme Court that no step should be taken to recover or to adjust any excess amount paid to the petitioner due to no fault of the petitioners, as the petitioners were no way responsible for the same. In view of the settled position, as stated above, it is therefore directed that the deduction of the amount of rupees 1,97,832 done by the authorities in the Assam Power Distribution Company Limited is held to be incorrect, and the said amount should be repaid to the petitioner. It is further directed that the authorities should repay the said amount within a period of 1 month from the date of receipt of this order. Petition is disposed of.
The petitioner may be directed to convey his
Okay.
payment details. To
Further, the petitioner is directed to file a representation
Very
before the authorities concerned along with the copy of this order and place his claim before the authorities.
Deeply able.
as, at the earliest. Petition is disposed of. Acha, you can take back the judgments. The covered judgment and A2 details, Rafiq Mashi. Rafiq Mashi you had given, right?
My lord.
Good for me. A2. Yes.
Deep.
Ouch. Gosh. Yeah, yeah. It's okay, it's okay. You have not hurt yourself, right? Push to one, na? Ah, ठीक है. हाँ, कोई बात. Yes. 19? Yes, Mr. Sharma? Huh?
The last occasion, they have paid for time for filing affidavit.
Lordship, we have received instruction.
Acha.
Make them affidavit.
So instructions will do, not, affidavit not required, I believe, Ms. Bhattacharya?
Because they already have received MSCP benefit, Lordship. I have marked one page, Lordship, where the name of the petitioner appears. If your Lordship feels, then I can file the affidavit or Lordship.
No,
may
not
peruse
required.
this.
MSCP is what?
Modified assured
Oh,
career
yeah,
provisions,
assured career progress.
where the promotions are not possible,
Yeah.
Lordship, stagnant.
Stagnant.
The paras, Lordship, the petitioner so and so. There are other cases also.
So you are entitled to be
And
under
on
the.
that,
That has already been, Lordship, this is a second round of litigation. Lordship may kindly see page 45. That is the first round of litigation, direction.
Yes. Hmm.
Direction was to consider for promotion. That is the last.
then Lordship may
paragraph
kindly
6.
come to page 2 of the
To
instruction.
formulate an appropriate scheme providing for additional appropriate promotional relief in view of the acceptance of the ex-cadre and would not be covered by promotion. Okay. The relevant scheme be framed within. So scheme is framed.
Yes, scheme is framed. Lordship may kindly
yes.
come to page 2 of the instruction, Lordship.
Page 2 I've seen.
Yes, Lordship.
So that is,
Because-
it will govern.
Yes,
Whatever was given in 5612.
Lordship.
So also observe that the scheme also cover isolated
Yes,
posts.
the
So this
scheme has been framed, Lordship. This is the notification of
This
the
is-
governor, 6 July 2017.
2017.
Yes.
So this scheme will cover your case
Yes.
also.
This scheme, my lord, actually what happens, on the date of passing this order, the petitioners were entitled and petitioners were getting the benefits of the said scheme, my lord.
Then?
Even after knowing this honorable court passed the order for consideration for promotion.
No.
So, my lord, this scheme is not a promotional benefit, my lord. This is a different.
But
my lord.
why, they said that, because you are an ex-cadre post, you are working in an
Yes.
ex-cadre
Yes,
post,
that
you
is-
don't have any
That's the problem.
promotional avenue.
Yes.
That is
Scheme
true.
provides.
Yes.
That is true, my lord. That is true, my lord. And my
But
lord,
then
what happens
if-
in this case, my lord? These petitioners were, direction of this honorable court was properly not considered by the authority. That is why we are before this court for the second time. So if they do not file the affidavit, I'll make my argument in the next, another day. Because, my lord, there is a judgment of this honorable court, division bench passed by this honorable court, my lord.
Okay, then
passed
you
in
make your
2019.
arguments. Then let her also file the affidavit. Okay.
Yes, my lord, that will be better, my lord.
Okay, heard Mr. J. Sharma. Learned counsel for the petitioner and Ms. M. Bhattacharjee, learned additional senior government advocate for respond number 1 and 3. Ms. M. Bhattacharjee, in compliance with the earlier orders, have placed an instruction received by her in the month of April 2026. No.
No,
Received
Lordship,
by her,
this
no.
is on 27th May
Yes,
26.
received by her on 27th of May 2026, by which it was informed that that the petitioners were were given what benefits under the scheme,
MACP scheme, Lordship.
under the
MACP.
MACP scheme formulated on 6th of July 2017. And as such, they were entitled to get promotion under the said scheme. However, Mr. Sharma submits that it is a subtle position that they were entitled for the benefits under the said scheme, but still they were not considered for promotion. However, he submits that he requires some time to go through the matter and place it before this court. In the meantime, Ms. M. Bhattacharya is also allowed to file her affidavit incorporating the said instruction in the same. List this matter on? List this matter on 15th of July,
Lordship.
Wednesday. Okay.
Deeply obliged, Lordship.
Huh? Okay. I have a small matter to be taken in the chamber. It's a matrimonial issue. So after taking up that, I'll come back. So that will take around 10-15 minutes, suppose. Okay. If it takes long, I'll send the information. Okay. Item 18, as Bhattakur. Yes. Oh, same thing. Oh, they have the information. I thought it would be called up at 2. Okay. Good. Yes, Ms. Sharma?
Lordship, I have received the instruction. It is not charge sheeted.
Okay.
Yes.
Then
So,
whatever
same
is required.
line dispose of.
Heard Mr. S. Bhattakur, learned counsel for the petitioner, and Miss U. Sharma, learned. You, Miss
Government
Kalpana Devi, you have Kalyani Devi, you have some matter. Where? What is your matter? 37.
Maybe reach
After at 2 o'clock, after 2. Even if it reaches before that, I'll fix it at 2.
Yes.
Heard Mr. A.
We'll check, let's do non-payment of.
I'll take it up in the second half. Yes, and Ms. U. Sharma. By this application, the petitioner has, by this application filed under Article 226 of the Constitution of India, the petitioner has prayed for his consideration for promotion with, what way is that? Prayed for a consideration or what? Wait, no. Has prayed for consideration of his, has prayed that the respondent authorities should consider his promotion to the post of Lance Nayak, within bracket AB, capital AB, from the post of driver constable with the required service benefits, with the service benefits. The case of the petitioner is that he was working as a constable driver at 28 AP Assam Police, within bracket IR, bracket close, Battalion Panbari Dhubri. While he was working in the said capacity, while he was working in the said capacity, he successfully completed his DNM course via order dated 24/12/2015, issued by the Deputy Inspector General of Police, Assam, and subsequently posted at Special Task Force Assam Simantapur, Gauhati. And subsequently on being released from 20th Battalion, the petitioner joined in STF on 31/3/2016. And since then, the petitioner is working in the said STF. Para. While the petitioner was working as such, he was arrested in connection with Gorchuk PS case number 191 of 2017 under section 384, registered under section 384/34 IPC. Read with, no.
Address section, no?
Added section. Registered under section so and so IPC, full stop. Later on, more offenses were added in the said case to the effect of section 365/342 of the IPC. And he was sent to judicial custody. Full stop. The petitioner was, however, released on bail subsequently. Para. On being arrested, the petitioner was placed under suspension while order dated 1/6/2017, and a departmental proceeding was initiated against the petitioner for serious misconduct and dereliction of duty. Full stop. Aggrieved thereby, the petitioner has submitted a representation before the authorities for his reinstatement. And where is that reinstatement order?
Page 37.
And considering his application, considering his prayer, the petitioner was released from suspension and he was back in his service. By order dated, released from suspension by order dated 18th of November 2017, and he was back in his service. In the said order, it was stated that departmental proceeding will continue against the petitioner. In pursuance thereof, in pursuance thereof, the petitioner was served with a show cause notice on 15th of September 2017. Oh, this was before. Show cause was before. In pursuance thereof, Nakoba. Before the said order dated 18th of November 2017, the petitioner was served with a show cause notice on 15th of September 2017. By which he was directed to show cause as to why. Show cause for the charges to the effect that while he was posted at STF, Simantapur, Gauhati, as driver constable on 11/5/2017, he accompanied another police personnel and proceeded to a particular place in a government vehicle wherein the victim and two others were picked up and money was demanded from them, and as a result, money to the amount of rupees 4 lakhs was paid, and the said victims were released on the same day at around 8 p.m. on 11/5/2017. For the alleged serious misconduct and dereliction of duty on his part, the petitioner was served with the said show cause notice. Full stop. A statement of allegation was also appended with the said show cause notice. Along with the list of documents and list of witnesses. During the during the said departmental proceeding, he did not file reply to the show cause.
That was
Not there. During the departmental proceeding, the victim, by his letter dated 7/12/2017, addressed to the disciplinary authority, had intimated that he had lodged the FIR alleging that he and others were arrested in connection with selling and purchasing of petroleum, and that they were released after they paid a huge sum of money to the STF police personnel. But in the said intimation, it was clarified that the petitioner and others were not involved in the said demand and taking of money. And a prayer was made to drop the charges against the petitioner and others. Thereafter, the inquiry officer had submitted the inquiry report before the disciplinary authority. And on the basis of the same, the disciplinary authority had passed an order on 21st of March 2020, stating inter alia that, no, you had submitted a written statement, but that was after the inquiry report perhaps, that the written statement filed by the petitioner was considered. Oh, no, no, no. That was before, after show cause. Acha. Nalage de. Etu nalage. It was considered nalage, no? Held that the inquiry officer had given a report dated 30/1/2020, wherein it was stated, 31/2020, stating inter alia that charges of serious misconduct and dereliction of duty against the petitioner were not proved. And in pursuance to the said findings submitted by the inquiry officer, the disciplinary authority on further examination of the relevant records agreed with the findings of the said officer and the charges leveled against the petitioner. And the charges leveled against the petitioner was stated to have not been proved. Was stated to have not been proved. In consequence thereof, the disciplinary authority held that the period of suspension with effect from 2/6/2017 to 18/11/2017, excluding the period of judicial custody, was treated as that the petitioner was on duty. and the period of judicial custody was stated to be, was treated to be dies non, that is, dies none, that is on the principle of no work, no pay. By the said order, the departmental proceeding was disposed of accordingly. In pursuance to the same, the petitioner was back in his, was in service, right? So to drop, not again. Thereafter, by order dated 27th of September 2023, the Secretary to the Government of Assam issued a notification that the Governor of Assam had given approval to implement an assured career progression scheme for 3 ranks. That is, for constable, the promotion should be made to Lance Nayak, and from Lance Nayak to Nayak, and from Nayak to Havildar. Subject to the condition that the employee should complete at least 8 years of regular service. In pursuance thereof, the Additional Superintendent of Police, by his communication to the Assistant Inspector General of Police, had intimated that he had enclosed the service particulars of all the employees. Employees, you said, or what? All the police personals. Police personals, as per prescribed format for providing benefits of assured career progression scheme. Who prepared this chart?
The additional SP, STM.
The additional SP. And in the said information, it is seen that in case of the petitioner, it was stated that the departmental proceeding is continuing, which, however, is not the fact, because by then the departmental proceeding was disposed of. It is the case of the petitioner that number of promotions were made under the said career progression scheme, but he was left out in view of the said information. In view of the said incorrect information. As such, aggrieved, he made a representation. He submitted a representation before the Director General of Police. What happened to this?
No action has been taken.
But till date, he submits that no action was taken. Para. The learned counsel for the petitioner submits, Mr. S. Bhattakur submits. Where did you show that Janki Viraman's case? Where was it mentioned? In the petition, somewhere it was mentioned. In their affidavit.
No, but there's an office memorandum.
Oh yes, that office memorandum. Has placed the office memorandum.
Page 9, page 95. Then portion is page 97.
Dated 9th of May 2006. Page?
Page 97.
90. Oh, that's a translated, that's a typed copy. Achha, that's an original. So what is the relevant page? Yes.
Page 97.
Oh, wherein dated so and so. wherein it was provided in para number 5 that there is no requirement of furnishing a separate integrity certificate to the Departmental Promotion Committee or any other authority. And that in terms of the judgment of the Supreme Court in Union of India versus K.V. Janki Raman, reported in 1991 4 SCC 109, wherein it was held that no promotion can be withheld on the basis of suspicion or doubt. It was further full stop. It was further held by the Supreme Court that when any case is pending against the employee and the same is in this investigation stage, no promotion can be stopped. However, the matter would be different if charge sheet is filed. Para. In the instant case, it is seen that the petitioner was arrested in view of a criminal case and the investigation is on. The learned counsel for the respondent, Ms. U. Sharma, on being asked by this court, had placed the instruction that investigation is yet not completed and charge sheet is yet to be filed. Full stop. It is also seen in the instant case that the petitioner was exonerated of his charges by the disciplinary authority and the disciplinary proceeding was disposed of on 21/3/2020. And before the same, he was also reinstated in his service as driver constable in the STF. Further, the information given by the additional SP that the departmental proceeding against the petitioner is on is also an incorrect information. Because the said information was given after the said DP was disposed of. In view of the same, and in view of the judgment passed by the Supreme Court, there is no impediment for the authorities concerned to promote the petitioner to the next higher post of Lance Nayak if not found ineligible for some other reasons. Accordingly, this petition is disposed of with a direction that the authorities concerned would consider the promotion of the petitioner to the next higher post of Lance Nayak in view of the exercises undertaken by the authorities concerned for such promotion. The said exercise is to be completed within a period of 1 month from the receipt of the certified copy of this order. The petitioner is directed to place the same before the authorities at the earliest. Petition is disposed of.
He should be promoted from the date of his universal promoted.
It is further directed that the petitioner should be considered for promotion to the next higher grade from the date on which His juniors were promoted. With this observation, petition is disposed of. Okay? Yes, Janki Raman, you can take Mr. Bottom. Petition is disposed of, huh?
Item 21, also made item 21.
Page 21.
Item 21.
Uh-huh.
Item 21.
Yes, item 21.
20 and 21 both are tagged together.
So I'll take up 21 first. 21 is a review.
Review.
Acha, Mr. You are ready?
Lordship, he has filed a leave application, for filing review, Lordship. Review is not numbered yet, Lordship.
Oh, review. Oh, filing number.
Lordship.
Because in this particular case, one selection process was challenged by two repetition.
But review should go before the same bench?
No, Lordship, only that are solved in the transfer.
Okay.
Cases like this, Lordship. The deputy commissioner.
But review is not numbered.
Lordship.
Because
Delay.
leave was not granted, that is why.
Delay is there. No.
That he was not a party in the writ proceeding. So he has filed a leave application.
You are affected.
Yes, Lordship.
Lordship, fact of the case is like this, Lordship. Deputy Commissioner Nalbari has advertised post of last month. The selection process we have appeared. And the two repetition also filed challenging the selection process. Challenging that 1:4 ratio was not fulfilled. That post against one post, 4 persons should be selected in the written test. Some person has not qualified, they were not selected. Accordingly, 1:4 ratio was not fulfilled. Repetition was filed challenging the selection process. That ratio was not fulfilled. That repetition was disposed of by this honorable court by another repetition in 23 itself. Thereafter, without knowing the actual fact, another repetition has been filed, challenging the same selection process on the same ground that 1:4 ratio was not fulfilled.
No, what happened to the first repetition?
Dismissed.
Dismissed, okay.
That authority can go ahead with the selection process.
Because there were no candidates.
There is no irregularity. Ultimately, the second repetition was filed challenging the same process. Honorable Justice Suman Sam has remanded the matter to the authority to take a decision. Now they have taken the decision and challenged this, set aside the selection process, which has already been upheld by this honorable court. And we are the affected party. Honorable court, we have filed a repetition challenging that the action of the authority is wrong. We have filed a separate repetition challenging the action of the authority because already selection has been held to be valid. Because in second repetition, authority has cancelled the selection process. We are the affected parties.
But authorities can always do, the first repetition was dismissed.
Selection cases can be set aside on the two grounds. When selection process is made arbitrarily and there is a malafide or anything wrong committed by the authority. When selection process has been upheld by the one single judge of this honorable court by earlier judgment, in subsequent judgment, it has been remanded back to the authority again, ignoring the earlier order passed by this honorable court.
That was not placed.
Not placed. That is why also we have affected party. We have filed a review petition challenging the order of remand. And that order we want to leave because we are the affected party, we are the selected candidates. The leave application, Lordship will get the leave only to file the review application. Ultimately, Lordship will hear the review application. Finally.
Only leave.
One leave.
You don't object to that granting of leave.
No.
Petitioner also no objection.
But whether it's maintainable, I mean.
Maintainable also.
Review,
We are the affected
start grounds order 47 or what? This is
47.
47. So only on error apparent, it was not placed.
Because that order was not placed before.
It was not placed. Whether that will be an error apparent.
Error apparent. Because earlier order passed by this honorable court was not placed before the last second judgment.
And there is one more ground that if documents were not available with you that moment, documents were available because our order was there.
Take something different, Lordship. First repetition was filed by some general category candidate.
Achha.
Their allegation is that for general category, 7 posts are reserved. 7 posts are specified. 7 posts for general category, if follow the 1:4, then 28 candidate has to be called for. Honorable court has called for the record, found that 28 candidate belonging from the general category is selected. So in this ground, that repetition was dismissed.
So 1:4 was maintained.
So far as general category is concerned.
General category.
Other category that read court has not enter
That
into
will be
exam.
The general candidate scheme, so there is maintained, so it was dismissed.
This was
It
this
should not have been dismissed, disposed of.
dismissed because their allegation is that 1:4 was not fulfilled.
Complied
That's it. That is.
But by
Is it-
calling the records, they have seen that 1:4 actually is
uh,
complied with as far as general
General
category
category
is.
concerned. He is OBC category. Lordship. Petitioner is OBC category. Second petition was filed for non-declaration of the result. Lordship. That they are not challenging in the select list or any other. This is the facts. Lordship.
So in that case, it was remanded.
We have filed our detailed affidavit. Lordship.
Okay,
that
I'll keep the maintainability of the review open
Okay.
and then,
Okay.
okay. By this application, review, it will, leave application is where? IA, civil
Yes,
1771. Acha, IA civil 1771 or different, huh? This is an application filed by the applicants seeking for leave to file the review application, to file a review application as an aggrieved party against the order dated 25/9/2024, passed in writ petition number 1505 of 24. This is Justice Suman Shyam's order. 2024. It is stated by the applicants that by order dated 25/9/2024, the matter was remanded back to the, where is that order?
Lordship,
Page
page
22.
This is
Page 20.
Justice Borua's order. Where is Justice Suman Shyam's order?
Page 22.
Acha.
page 22 of the review petition.
Of the I, yes.
One page 20.
Was respondent shall take a decision in the
Page
matter.
20.
Was remanded back to the respondent authorities to take a decision as to whether they would pursue with the selection process or go for a fresh selection process for appointment to the post of
Lot Mandal.
for appointment to the post of Lat Mandal. Commenced with the advertisement by the Deputy Commissioner,
Nobody.
Nalbari. And in pursuance to that remand order, the authorities had cancelled the entire selection process. Full stop. Mr. Goswami, S.K. Goswami, Learned Counsel for the applicant, submits that prior to the present order, prior to the order dated, present 25/9/2024, there was an order passed by this court dismissing a writ petition on the ground that, there is a writ petition filed by the candidates belonging to general category.
Lordship will find page 18. They are submitting all these things. Everything has been discussed at page 18.
Acha, I will not write so much. Before, there was a writ petition by which the prayer of the petitioners, before before that, there was a writ petition
Or the same selection process, challenging the same selection process.
challenging the same selection process on different ground.
Different ground.
On different ground, which was dismissed by this court.
Not different ground, Lordship, same ground. Lordship will find in the order itself. 1:4 has not been followed. Lordship will find page 22.
Of the IA.
IA, Lordship. Lordship will
IA
find
22. This
page
is
22
Justice
the
Suman
order
Shyam's
passed by
order.
Justice Suman Shyam.
Huh.
Lordship will kindly see middle portion. Ratio 1:4 as per requirement, the rule was not fulfilled.
This was our instruction. This was our instruction.
Prayer is different, but that is the
But
ground.
here, you have not placed the judgment, so how can that be considered by this court?
No, I am not saying that considering. Lordship will say same ground. I'm saying the same ground it was set aside.
But then that order was not placed before this court, right? When this order 25/9 was passed, yes, dismissed, but the learned counsel submits on different ground, dismiss simply, which the learned counsel submits that the same was not placed before the court while Order dated 25/9/2024 was passed. As such,
And we had
As such, the petitioner has preferred this review application on the ground that the same was an error apparent on the face of the record. In view of the said facts and circumstances, this court deems it fit to allow the instant application, allowing leave to the petitioners to file the connected review petition.
being affected
Being affected party. The registry is directed to register the review petition and place it before this court for admission. Review to register, and what about this writ petition?
After review application, that will be heard. Because in the petition, we have said that the authority has passed this order regarding setting the selection process with error on the fact that already the selection process has been upheld by this honorable court and that order was not placed. That is
No, writ petition you have filed, new writ petition. Okay, that we will consider after review. Yes, Mr. Secretary. I can tell you. Wait, I'll take up one matter. 22 is what?
Lordship, the Paraguay's comment, so 2 weeks time may be granted to file application.
Miss Devi, Miss R. Devi, learned CGC,
CGC.
prays for a week's time to file the affidavit in opposition. As she has already received the Paraguay's comments, prayer is allowed. List this matter on 10th of, no wait, list this matter on no, not 10th. On Friday. What's Sunday? Friday 25. Okay. On Friday. On 12th of June. Next Friday. 19th of June. 23. Time is sought for what? Time? You want time?
This was issued on 7/1, madam.
Uh-huh.
In this matter, notice was issued on 7/1/2026.
Oh, after November 25, it has not been listed.
Yes, Your Honor.
Okay, you will file affidavit. Miss Neog.
Yes, Your Honor.
Miss D. Neog, learned counsel appearing on behalf of respondent number 1 and 2 makes a prayer that she be allowed some time to file the affidavit in opposition. Prayer is allowed. Miss, you also have some prayer?
Lordship, I have no role, Lordship. I have received the instruction.
Instructions will do. You will also file. Mr.
R.K. Talukdar.
R.K. Talukdar, learned counsel for?
Accountant General.
For respondent number 3.
Yes, Lord.
That is Accountant General also makes a prayer to file his affidavit in opposition and has prayed for some time. Prayers are allowed. List this matter after vacation.
Yes, Your Honor.
List this.
My lord, I didn't receive any pension, my lord. And what is a similar order, my lord, they can also take instruction whether it is applicable.
Provisional pension is received, my lord.
I have received for provisional pension, but in terms of 2013 payroll, my lord. I am not even getting the 17 payroll, my lord.
So can you file it on 20th?
If they file it 20th, then immediately after reopening, my lord, by 15 or 16th.
Okay. List this matter on 15th of
15th.
July.
My lord.
It is further directed that the affidavit should be filed before the next date. And liberty is also given to the petitioner's counsel to petitioner to file his reply if any
Right. Great.
before the next date. So all the things should be
Yes,
done
okay.
and then. Okay. 24 and 62 together. Acha, analogous matters.
Implement petition. 52 is an implement petition.
And what about 24?
24 is a read petition, Your Lordship. We are including the respondent bank, Your Lordship.
Acha.
The matter pertains to non-payment of compassionate family pension, Your Lordship.
Okay, you want to implead whom?
And the State Bank,
State Bank.
respondent number 10.
State Bank role is in between, their role will be there, whether they are necessary party here.
Actually, the petitioner's father died in harness.
Mm.
He was an fourth grade employee in the Director of Health Services, and he died in 2022. And the compassionate family pension from 22 to 26 has already been deposited in the bank account of the guardian of the petitioners. But the bank is keeping the amount in hold.
Oh.
That's why the
Amount is already submitted
Lordship.
in his account.
Lordship.
And then one can take it out. How can the bank stop?
That is the reason. Your
But the
Lordship.
bank had stopped the withdrawal.
Yes, Your Lordship, it has kept the money in hold. So we have made the bank a party,
SBI.
SBI, respondent number 10.
Okay, maybe they have some order and so. Heard Miss Aforesaid, Learned Counsel for the applicants. This is an application for impleading State Bank. Where is that? Applicants?
Respondent.
Where is the nomenclature of the SBI?
Page number 4, Your Lordship. The
For, okay. Acha, for impleading the branch manager of the State Bank of India, Gitanagar branch, Gauhati, as party respondent
Number 10.
in the,
Number 10.
a party respondent in the in the connected writ petition. The learned counsel for the petitioner submits that the petitioner's father,
Petitioner's father, Your Lordship.
that the petitioner's father had died in harness, and the pension, family pension, accrued to the petitioners was although paid and submitted in the account of the petitioner, but the same was not allowed to be withdrawn by the State Bank of India. As such, she submits that the State Bank of India becomes a necessary party in the instant writ proceedings. In view of the said facts, the petitioner is allowed to implead the said the said party as respondent number 10 in the connected writ petition. The petitioner is further directed to file the amended cost title and the necessary correction.
Plus, an amended cost title may not be necessary, Your Lordship, because everything is done. Only if the State Bank brings the
But
instruction.
for amended, you have to make them a party in the writ. So that CIS or what the system has to be changed, right? Amended cost title and resultantly, ki kuslo? And the necessary correction would be done in the CIS by the registry. I is allowed.
Deeply obliging.
Writ petition or by virtue of this order, writ petition? Implead ho jao some types of, no? Yes.
Next date, Your Lordship.
Oh, writ petition to dia. In view of the order dated, in view of the order passed in the IA, list this matter on?
Next week, Your Lordship.
But you will file your amended cost title, then the necessary changes will be made, right? List this matter on 22nd of June, 2026.
Obliging, Your Lordship.
Okay. Rest of the matters are through. Ouch. You have something to say, Mr. Upamanu?
No, Lordship.
Oh, yes.
Lordship, I have a small submission, Lordship, for the next matter.
Huh.
Lordship, this matter, I need some time because conversation is going on between the Social Justice Department, between the officials of the Social Justice Department, as well as with the officials of the Women and Child Empowerment Department. So
Mr.
negotiations is
Prakash,
going on.
Uh-huh.
Negotiations is going on because the thing is that in similar matter, Honorable Court had directed us to amend the service rule. That service rule, Social Justice Department cannot amend because that service rule was being made by the earlier Social Welfare Department.
Acha, acha.
So regarding that taking of the employees which falls under the Social Justice Department and some of the employees which falls under the Women and Child Department, that negotiation means that conversation is going on between the two departments as I am being informed today.
Okay.
So I need some time in this matter, Lordship.
So what is that matter? Which item number?
This 25.
25 at likha. Heard Mr. B. Purkaster, Learned Counsel for the petitioner, and Mr.
RM Das.
RM Das. Oh, you are Mr. RM Das. Actually, I never knew your names with abbreviations. I mean, RM and all those. So I couldn't make out. Acha, Mr. RM Das, Learned Standing Counsel for
Social Justice and Empowerment Department.
Social Justice and Empowerment Department. Mr. RM Das submits that the matter that the instant writ petition relates to a challenge made to the what?
Service rule
Service rules framed by the Social Welfare Department,
by the then social justice.
by the then Social Welfare Department. And now that negotiations are being going on between the Social Justice Department and Child
Women and
Welfare,
uh.
Women and Child Welfare Department for what?
Taking of the respective employees, taking back the respective employees.
Of taking for taking back the employees working in the Social Welfare Department.
Yes,
And as such, he has prayed for some time. Prayer is allowed. List this matter on
after 3 weeks.
after for vacation.
Yes, yes.
My lord,
Please.
some urgency is there on my part. He has requested me, so I have, my lord, the
Acha, acha. Okay. List this matter on.
22nd of
After
June, my lord.
3 weeks, Lordship, at least 3 weeks, otherwise.
3 weeks will not be there.
Okay.
3 weeks is after 3 weeks means vacation starts.
Vacation.
So list this matter on 22nd of June. Mr. Borua?
Yes,
Admission. Oh, yes. Yes, Mr. Borua.
Accommodation, my some problem is going on. So
Oh.
any day. Except Thursday, Tuesday, any day. Lordship. Tuesday full bench is there, any day.
Ah.
Lordship. Except Tuesday.
Let it be fourth time if it is third time.
What is going on, my lord?
Okay.
Nothing is going on, Lordship. Nothing is going on, Lordship. If he wants, then he can proceed, Lordship. My part any day, Lordship. That is also
That
not
will be
difficult.
big and difficult because I
That also
forget.
not, I have no difficulty, Lordship.
So when can you do it? Wednesday? Coming Wednesday?
Thursday.
Thursday?
Thursday.
Huh?
Thursday.
So Thursday 11th?
Thursday.
11th.
Thursday.
As prayed for by Mr. K. Gogoi, Learned Standing Council for Higher Education Department, list this matter on 11th of June.
Lordship. Not at 2, Lordship. As and when matter listed, I will be there, Lordship. At 2, it will be difficult.
If you are
It will
not
be
there,
difficult, Lordship. It will be.
I'll accommodate both of you.
Today this matter is come on as item number 54. Well, now it is called because it is fixed at 2.
Thursday, Lordship, not
He is
so
paying
much.
for the
Thursday,
accommodation, my lord. He has raised the.
Okay, at 2 o'clock.
2 o'clock.
Thursday not matter, so many matter will not come, Lordship. 2
Uh-huh,
o'clock, I am
it
not difficulty,
is
otherwise
Friday, so
Friday.
so
Thursday.
okay. I'll accommodate both of you. When both of you are there, I'll do it.
Lost.
I'll take it up.
Oblige.
When, my lord?
11th of June.
Not 11th of June.
Thursday. 11th of June ना Thursday है शायद Thursday. उसको Wednesday में problem है बोला.
Thursday.
चले 11 একটু 11 জুন আপো Thursday হয়. Okay. Yes, Mr. Bothakur.
Your Lordship, here we have
Ah.
received the Parawise comments.
But
But-
Mr. Bothakur is not there. This is what Shantanu Bothakur or Saurav?
Oh, 27. Oh, sorry, I'm sorry.
Huh? D. Gogoi is also there. Okay, let it be called after some time, Mr. Bora. You are not Mr. Dikshit Gogoi. You are not the D. Gogoi here. Oh, acha, so you are there.
27, I think.
27 years.
So, in this time, notice was issued. My lord, there's file, to file affidavit.
Huh.
Here I appear for respond numbers 1 and 2.
Yeah.
We have received the Parawise comments, but it is not adequate, Your Lordship. Just 2 lines and they say that it's a Parawise comment. So I have to again write to them to seeking a detailed Parawise comments, Your Lordship.
Okay, let them file the affidavit then. Okay. Heard Mr. D. Gogoi. Actually, I thought D. Gogoi is Dikshit Gogoi. Acha, yes, D. Gogoi, Learned Counsel for the petitioner, and Mr. D. Bora,
Oh, 1
Learned
and 2.
Standing Counsel for respond number
Not
1 and
standing
2.
counsel, government advocate.
Learned Government Advocate for 1 and 2. Yes, Miss. Miss. And Purkast Kayastha on behalf of R. Dubey, Learned Counsel, appearing for respond number 4. Mr. Bora submits that he has the para-wise comment, but then the same is not complete, and that he has to have it, uh, has to have a proper one, and as such has prayed for some time. Prayer is allowed. List this matter after vacation.
After vacation.
List this matter on 17th of July.
Got it. Diploma.
28.
May I please, Lordship?
Yes.
Lordship, in item 28 for respondent number 1 and 2, I am appearing. Lordship has issued notice earlier. Some instruction has come. Kindly give us 3 weeks time. We'll file affidavit in the matter.
Okay, Miss. Mr. M. Nath, learned senior government advocate, prays for an accommodation and submits that the respondent would file the affidavit. Prayer is allowed. List this matter when? After vacation?
Yeah, after vacation.
After vacation? Okay.
Lordship.
List this matter on 16th of July. Okay.
Can it be on 20th? 20.
20.
20.
28th July.
Lordship.
You are
Apply,
appearing for Mr. Nath. Yes. Acha, oh, kiba mo M Nath, D Nath, huh? Mo M Nath hosu no? Yes. Okay, Mr. Nath.
29.
Transfer order. Though I know my limitations, my lord, the service which I'm into, but since the wife of the petitioner is suffering from some sort of issues with after childbirth, the learned CGC was asked to obtain instructions to that to the effect that to where he is posted, it's enough medical facilities are there.
So there are.
There is enough medical facilities and she can avail that.
So
And
wife is not working.
wife is not working. And even yesterday, petitioner was relieved also from here.
Acha. So he was transferred from where to where?
Kachar to Jharkhand.
Kachar to Jharkhand.
Odisha.
To Orissa.
Yes.
What does he work as?
Constable.
CRPF, constable. So he will take his wife there, Orissa, and he will be given enough medical
If
facilities.
he wants to take her, the medical facilities are there. If she wants to go there, she can avail the facilities.
Okay.
That will be recorded.
That will be recorded.
And my lord, in case of some medical facility, my lord, they will consider, my lord, is not transfer, my lord. Any issues, anything, they will give adequate facilities.
Facilities, and if further in the coming time, if they desire, they can also post him somewhere else.
No, because he is in the homestead for more than
Long.
10 years.
This is
Yes.
beyond my pleadings, ma'am. So I
That
would
is not there.
Okay, heard Mr. Dikshit Gogoi, learned counsel for the petitioner, and Miss Bijita Sharma for
All the
CGC, learned CGC. By this application, the petitioner has prayed for quashing of the transfer order, right?
Well,
Wait, has prayed for setting aside and quashing of the order dated
Summer saying
22/12/2025. And has also prayed for restraining the respondents from giving effect to the said transfer order for the region of his ailing wife, for the region that his wife was ailing and that he has minor children. The case of the petitioner is that he was appointed, he was serving as a constable / GD at Counter-Insurgency and Anti-Terrorism School, Central Reserve Police Force, Silchar, Kachar. And he has been serving in the said post since the day of his appointment.
no,
That is,
he has been
so
more
he
than
has
2
been,
years.
it's okay. he has been discharged, and and in the said post, he has been discharging his duty to the best of his ability. It is the further case of the petitioner that while he was working in the said post of constable at Kachar, a transfer order was issued. Dated. Where is the transfer order?
I will find it page number.
21.
No, Malad, that 21, yes.
Ah,
His name.
transfer order. They dated
Serial two.
22/12/2025 was issued, by which the petitioner is transferred from Kachar from allotted unit Chhattisgarh. What?
No, no, Malad,
202 Battalion Cobra,
situated in Malad, this is situated-
serial number 2.
2. He was transferred from the from his serving place at Kachar to 202.
Yes.
202-BN-CO, O too small, BRA. And those are in capital letters. Cobra at Orissa.
Yes, sorry, sir.
Where do I get this?
But this is something I have checked, man.
Acha. In the state of Orissa. Okay. The petitioner states that his wife had given birth to his child only a few months back, and that his wife is suffering from suffering post childbirth, and as such, finding it difficult to approach on his posted place at Orissa, he filed a representation. Right, he filed a representation.
Malad, here, fine.
He filed a representation.
In Annex 2, Malad. Page
Page
18, man. It's a translated copy, man. Page 20 is the original.
representation before the principal, CIAT School, KRP, Dayapur, Silchar.
It's not KRP, man. Some, it is KRP, man, CRPF.
CRPF.
Translation.
Oh, KRP no, CRPF, Central Reserve Police Force, huh? Any reply to this?
Representation.
Huh?
Representation was considered in the previous year also because normal tenure is 3 years. After completion of 3 years, he was subjected to transfer, but he submitted a representation on the same ground that we considered. He again submitted another representation, but on the same ground, we cannot give him twice the same opportunity.
Which was considered, and on the ground that he has completed 3 years in the previous place of posting,
More than 4 years.
or more than 4 years
Present place.
at the previous place of posting, that is at Silchar, in his present place of posting, right? In the present place of posting, that is at Silchar, the said claim was not acceded to. Being agreed, the petitioner as such approached this court, challenging the said transfer order. Para. During the pendency of the instant writ petition, the learned CGC was asked to bring the instruction as to whether medical facilities are available at the place of posting to which he was transferred. And in the compliance of the same, the learned CGC has placed before this court that necessary medical facilities are available at the transferred place, that is at Orissa, right, at Orissa.
And he was already relieved yesterday because no stay order was there.
She, full stop. She further submits that the petitioner was relieved from his present place of posting, that is at Kachar, a day before. What else? What else in the documents? Any more facts?
Nothing.
As such, this court directs the petitioner to join at his place of posting at Orissa, and that he need not worry about the medical treatment of his wife, since medical facilities are available at the said place. Petition is as such disposed of. Not dismissed, disposed of.
Disposed of.
Disposed of.
And these matter, I have filed wakalatnama 2 days back, madam. Whole matter, I understand.
So you are the new counsel here.
Yes, madam. I have to file a reply.
So you have filed your affidavit?
Yeah, I have filed a
Okay, you'll file reply. Mr. D. Gogoi, learned counsel, submits that he has filed his wakalatnama on behalf of the petitioner recently, and as such praised for some time to file the affidavit in reply to the counter filed by the respondents. Prayer is allowed. List this matter on.
July,
List this matter on 20, letter on 16, no, 7, 15th of July.
15 July.
Of license. Yes, Mr. Day.
You know, the pendency of the case,
Hmm?
order was passed, that speaking order was.
Mr. Dhar submits that the matter be listed on so and so, bring on record the order passed by the department rejecting the claim of the petitioner.
Yes.
That was March, May. So you have the order.
That has been filed by way of an affidavit. That needs to be challenged. So, my lord, I may be allowed to withdraw that petition, my lord, with liberty to challenge that.
So your claim was rejected.
Yes,
This is
it-
contempt. No.
No. It was, my lord, post facto regulation. In fact, during the pendency of the case, my lord, the order was earlier not served upon us. They came, on the last occasion, they came and said that that my claim has been rejected. So, well, that rejection order has to be challenged right as of now. So that has been filed by way of an affidavit.
What had you challenged in this writ petition?
No, we wanted post facto declaration. We returned in the meantime. And we filed a that was pending, representation was pending. During the pendency of the writ petition, my representative was disposed of with a speaking order.
So you have,
my claim.
so you will file a fresh writ petition.
Exactly, not challenging that particular speaking order.
Okay.
That is on lordship passed on.
Heard Mr. R. Day, learned counsel for the petitioner, and Mr. R. Dhar, learned standing counsel PWD, and Mr. What Sharma? And R. Sharma. Difficult to remember the abbreviations. Some are PK, some are NR, some are. Better to remember the names. And PR stands for?
Nivan Raj. NIVAN.
Nivan. You said PN Sharma.
NR.
NR Sharma, Nivan. Huh? Sharma for DBTC. By this application, the petitioner has prayed for an ex post facto regularization of his service after his retirement. It is also stated by the petitioner that he had submitted a representation before the concerned authorities, and during the pendency of the instant writ petition, the said representation was considered, and by a speaking order, the claim of the petitioner was rejected. As such, Mr. Day submits that he may be allowed to withdraw the instant petition with the liberty to file afresh if required. As such, this case is closed as withdrawn with the liberty, by giving the liberty to the petitioner to approach this court if required. Petition is disposed of. 57 years. You are there?
Sir will take the case in virtual manner.
Oh, he is there online?
Yes.
Whether Mr. Arunangshu Dhar or HR?
I'm appearing for respondent number 4 and 5.
Acha. And Mr. Chaudhary?
Yes, my I'm for the petitioner.
So today?
Today, my lord.
Pleadings are complete. Yes, affidavits
Yes,
are
my lord.
filed.
Please completed, my lord.
So you will do the matter today?
Yes, my lord. Yes, my lord.
Okay.
My lord, in this case, my lord.
Mr. Bora is also there. You are for?
1 and 2.
And Mr. Dhar for?
4 and 5. 4 and 5.
Okay.
I have received the affidavit filed yesterday only by
My lord.
respondent number 1, 3.
Hmm.
That is uh, the Director of Municipal Administration.
So you need time to go through or we are ready?
I will seek some instructions from my clients. This is a
My,
municipal board. 1 week time may be granted.
my lord,
Just
the
1 week.
issue is very simple, my lord. It's a pleadings is completed already. The I am, my lord, a retired municipal employee, a lady employee, my lord, now in old age, retired on 31/10/2021. The retirement benefit which is accrued during my service, which is duly admitted by the respondents, my lord. Now they are saying that the retirement benefit, the amount should be provided from the municipal fund or some others like that. My humble submission, my lord, I retired on October 2021, and this petition is filed on 1st August 2024. And today, my lord, it is 5th June 2026, my lord. So the amount is admitted, my lord. In similar circumstances, my lord, this honorable court directed the respondents to provide the retirement benefit. That, my lord, that order I will, my junior will submit, my lord. It is my junior is assisting me.
It's
So, my
okay,
lord,
I'll go through it.
yes, my lord. So a specific direction may be given. This is admitted position. They are not denying, my lord. This is my right to get this one. Only they are saying
Why
that.
was it not given to you?
Malad, may I just submit? I am the municipal board. Because of some financial crunches, doesn't have that much fund to pay that is admitted amount, but we do not have the fund to give that amount to the petitioner. We have admitted an amount, and as per direction
So,
of this
okay,
court,
now that the funds are available.
no. At present also that is not available, and we have asked municipal administration authority to grant us some advance or some uh, ad hoc advance or ad hoc loan so that we can give the amount to the petitioner.
So pension you cannot just not
No,
pay.
it's a municipal board. Otherwise, we could have paid. If we are a government agency, then we could have paid. Your Lordship is aware of the status of the municipal boards in the different districts. We are in loss. We have filed our financial auditor's report along with our affidavit as per the direction of this honorable court, and this will show the present current financial status of the board. We are running in loss. We could not even pay the salaries of the staff of the board. That is why we have asked the government to grant us some aid, but that they are taking the plea that under Section 50 of the Municipal Act of 1956, the board is to arrange all this amount yourself. But that doesn't preclude them to
Under the what? Under the rules, the board has to arrange funds
under
for
the
their own employees.
yes, yes, that is true. That is true. Under Section 50,
And
the
the
board has to
government gives them aid.
Grants in
government
it.
can give
Grants him aid.
grants in it.
Your
Government
lordship,
can
if your
give.
lordship recollects, a day before yesterday, there was a similar matter of a development council where Mr. Senior Advocate Mr. P.K. Roy appeared. And
There is
therein also
nothing.
we raised the same issue that we are not liable to pay anything with regards to pension or gratuities because the act itself is very clear. Section 50, subsection 3 of the Municipal Act, we have also annexed in
Yes,
our.
I have seen that they
it-
can only grant aid
If I
in
may,
case necessity arises.
if I may take your
Yes.
lordship to page number 70 of our affidavit,
So same status is of
same
the
status of
municipal
municipal
board.
boards also. Just as it applies to development authorities, same for municipal boards also.
So, okay, I'll give a direction to the government to give it by virtue of Article 21 of the Constitution of India. Since they can give grants, they'll also look into this aspect.
The lordship, that aspect, he has not raised that issue because in that, my learned senior had raised that issue, had cited that Supreme Court case. We may consider, but ultimately there is this particular section. Here there is a specific, if I may take your lordship to page number 69 of our affidavit, wherein it is clearly written with regards to gratuity or pension. Therefore, in that Assam Town Planning and Country Planning Act, it is not written that clearly, but here it is clearly written.
Page, what did you say?
Page 69, Annexure 1 of the Assam Municipal Act.
Raise me page 69.
Affidavit filed by us, Your Lordship.
I've got an extra copy, Your Lordship, if Your Lordship.
Maybe not, it is not put in the records.
Record.
What act you are showing?
Assam Municipal Act, Your Lordship.
Also, okay, I can get it here. 64 is the last page here.
My lord, a old lady, my lord, suffering from various ailment, my lord. This amount is very necessary for me, my
So
lord.
here, if I may take Your
Survival.
Lordship to subsection 3, gratuity or pension. A municipal board may, at a meeting, time to time make rules for gratuities or pension to be granted and paid out of its fund, who is established subject to the approval of the state government. So first they have to evolve a fund, and then they have to get approval from the state government for payment of, whether now in their affidavit itself they have admitted that they are liable to pay. It's an admitted position in the affidavit itself. So state has got nothing to do. They have to devolve their own. They have to devise their own strategy.
Have
They
they
have
made
to
any
generate
regulation?
funds on their own.
Any rules
Your Lordship,
by the
this is,
board?
Your Lordship, this is the act itself. Act
No,
itself.
have they
mandate.
made, board has made any rules and all?
I
No.
believe so, because
No, ma'am.
otherwise they would not have agreed to payment of provident fund or gratuities.
Acha,
or
Mr.
pension.
Dhar, municipal board has made some rules and all.
No, no, my lord. That I have to take instruction, but
Even development authority did not have any rules.
Rules. But they have, I think, because in their writ petition,
No,
in
no.
the writ petition itself, as also the affidavit filed by the respondent number 4, in wherein they have actually admitted this particular fact, Your Lordship, that they are
That is
liable to
admitted.
pay. They are liable to pay so and so amount. I was just going through it. Yes, Your Lordship, page number 28, 29.
29?
29. Terminal benefit to be paid to Srimati Monasa Rani Das. So gratuity is there in terms of section 53. Then leave salary is there. PF money is there. So I think they have. So this is a admitted amount. So they have to arrange their own funds now.
So this
They-
calculation is done by whom? Chairman,
Chairman,
municipal board?
respondent 4. So they have to devise their own funds. So I don't know how to generate the fund, but they have to generate the fund on their own. We only give them a particular amount of grant in aid. There is no scope as such to give them additional grant in aid, Your Lordship. That is what I have been told by the Director of Municipal Administration. Yearly, we give a particular grant in aid and they have to utilize it. How they utilize it, if they misutilize it, I don't know how they utilize it.
No, the
So-
chairman has calculated and also
They
there
have-
will be some rules, vagara.
They can sell out their assets. How they generate the fund, they can devise their own.
And where is the
rules also.
provision where government can give grant in aid? Where?
Yeah, in appointment and pay of establishment, section 50 itself says, Your Lordship, the board at a meeting may from time to time determine and appoint the establishment subject to the staffing pattern as may be determined. I'm reading from 51, subsection 1.
51.
50, subsection 1, appointment and pay of
The
establishment.
board at a meeting specially convened for the purpose by resolution in favor of which not less than 2/3 of the commissioners shall have voted may make regulations consistent. So, okay, may make regulations.
Yes, provided further, if I may take Your Lordship, that is very important. Provided further that the appointment of any officer or employee whose pay is wholly or partly contributed by the state government shall not be created or
Provided there are
without the sanction of the state government, and
No.
that every nomination to or dismissal, any such appointment shall be subject
Wait,
to
I'm
conform.
getting it. Where 51?
50 subsection 1,
50.
page 69 of the affidavit.
Acha, 50.
Wait, 50, 50.
50. Subsection?
Subsection 1. Then, if I may take Your Lordship, then again for 4, provident fund is there. Then 51. Next page, Your Lordship.
51 I've gone through.
Power of municipal board to frame regulations for establishments. So municipal board, they are a authority within themselves. So they can frame regulations how to conduct their function in day-to-day function, how to
So, but
give the
Mr.
salary.
Dhar said that there is no regulation in place. What about Mr. Chaudhary? Any
Yes.
regulations in place framed by the municipal board?
No, my lord. In respect of that there no specific regulation, so far my knowledge concerned.
And
My
how
hum-
did this calculation was done by chairman?
cal-
municipal board?
calculation
has
be-
to be.
because my lord, that calculation is done by the chairman, and
Hmm.
that is not disputed by the respondent, my lord. This is undisputed, and that has been admitted by their affidavit, my lord, by the respondent number 4
It's
and
okay,
5.
it's undisputed, but who will pay it?
Pay the
You have- the board has to pay it by generating their own funds according to the Assam Municipal
Correct.
Act.
Page
Correct, madam.
17 also
my,
of the writ
my
petition.
humble submission, my lord. It is I retired on 2021. Today is
Hmm.
2026, my lord. 6 years is gone.
That you have
Now
repeated.
only by saying that I have to generate a fund and then I will pay it. My lord, how can, if they are willing to pay it, they can easily can pay, my lord. They can easily pay, my lord. If they are at all willing, my lord.
No,
They are,
they can do it, but it's not
yes, my
provided
lord.
under the rules.
It is not,
Mr.
my
Dhar,
lord,
who was
matters
the
related to
employer?
the
Husband,
crores,
wife,
my lord.
or
It is only 12
Karimganj
lakhs amount.
Municipal Board is employer.
Uh-huh.
Karimganj Municipal Board is employer. He is not, this petitioner is not an employee of the state government. He is an employee of the Karimganj Municipal Board.
Like development authority.
Yes.
And
And
now, my lord, the municipality employee have been regularized. Although, my lord, I am not regularized because it is recently, my lord, the municipal employee has been regularized by the state government. Recently, my lord, the last 3 4 months back. So, at present stage, my lord, if my lord, I will continue the service, I may be regularized. But at my during my tenure, my lord, I was not regularized. It is right, my lord. But I retired on 2021, my lord, and today is 2026. How can, my lord, they are denying that undisputed amount, and they are saying that only the financial constant? This is not amount like a 12 crore, my lord. It is only 12 lakhs, my lord. And
My
for
lord,
this
if I may,
amount, my lord,
Petitioner
so
was the employee or her husband or something.
petitioner.
no, petitioner is the employee, my lord.
And
Petitioner is the
also, if
employee.
I may take your lordship to page number 17, as well as the letter written from page number 24, annexure 8,
Page number what, 14
22.
of the petition?
Yes, of the writ petition. One is page 17, which is letter written by the chairman Karimganj Municipal Board, and the second one is again written by the chairman Municipal Board at annexure 8, page 22.
This is your affidavit.
Not my affidavit, it is a writ petition, your
Writ
lordship.
petition, yes.
And they have admitted.
Why there are two copies? Acha, no. Yes.
They
my lord,
themselves
if I am
admitted.
permitted to speak, if my learned friends have finished, if I am allowed to speak something.
No, I'll
My
just
lord,
see page 22. Why it is relevant?
Because here the Karimganj Municipal Board has written to the petitioner. We have got nothing to do. Director of Municipal Administration has got no role to play here.
Okay, Mr. Dhar.
yes, my lord. My lord, my friend has shown your lordship to page 29. That is not under, there is no dispute that this amount is to be paid to the petitioner. Now, if your lordship can take up page 30, which is a part of my affidavit, this is written to the Director of Municipal Administration by the chairman on 7th of April 2025, prayer for release of financial aid. I know there is a bar under section 50 that they cannot, they have to arrange their funds of their own. But this amount, because of their financial crunches, the municipal board has asked for some financial aid from the government. Again, page 31, again the director was requested for some financial aid. Similarly, page 32, then page 33, the director says, no, we cannot provide you anything. Request kindly to provide necessary instruction and all. Now, page 34. What
Government said they
my
cannot pay.
they cannot pay. This is again we have requested on 26th of August that we have to pay to this petitioner. If your lordship will take page 34 for a
Acha,
moment.
you are from municipal board, right, Mr.
I am
Dhar?
for the yes, madam.
Yes, then?
Then we have not received any reply. Now they have filed affidavit. Now this honorable court has asked the municipal board to show that why they are unable to pay, to file their auditor's report. Now page 35 your lordship will take. This is the audited report given by the auditor's report for the year ended 31st March 2023. And this is there here it is shown surplus 26 lakhs 57,575. This is for the year 2023. Now your lordship will turn to page 45.
So, in the case of income and expenditure amount, of the surplus rupees so and so.
So and so. That's
This
for
is
that
what.
2023 it was surplus.
Hmm.
Now in 31st March 2024, page 45, your lordship will find.
Hmm.
Page
45.
45. 45.
Hmm.
This is the auditor report for 31st March 2024. And the
Hmm.
last line says in the case of the income and expenditure account of the deficit of rupees minus 40 lakh
Hmm.
6,733 for the year ended on that date.
Hmm.
And page 55, your lordship,
Hmm.
this is for 31st March 2025.
Hmm. This is
Last line in the case the
again
income and
deficit.
expenditure again deficit. This is the reason why the petitioner could not have been paid the entire amount till date. We are running deficit. We could not even arrange for the salary of the staff. Now
My
they
lord,
have
But
been
here in the
regularized, my
year,
friend.
in the year 2024, you had a surplus.
2023.
23.
23, I retired on 2021, my lord. 2021, I retired on.
On
So
31st
my
March
lord,
2023, you had a surplus. Wait, let
yes,
Yes,
Mr. Dhar finish.
yes, ma'am.
Then,
yes. Then thereafter we run in deficit.
hmm,
So as on date we are running deficit of more than 23 lakhs.
hmm,
So we have requested the municipal administration department to grant us some aid
hmm,
as a loan
hmm.
also, so that we can give that amount to the petitioner. She has admittedly retired as an employee of the municipal board, and we have compassion for her. She is an old lady, but the thing is that otherwise we have to sold our establishment, our computers, our everything, movable and immovable properties to give that amount to the petitioner. That's what we are left with. That
So
is
now
why
the
we have,
ball is in the municipal administration department.
if they don't
So,
give,
but
we have no other way to
so,
give.
Mr. Bora, try out, give some loan.
They have got assets, your lordship. They can sell off their assets, whatever assets.
Yeah,
What they can
definitely.
sell
We will
by selling.
dispose of removable and movable
By
properties.
computer,
That
by
would
selling
complete
a computer,
shutdown.
they won't be able to give pension to one
The
particular
district
person.
will
Because
be
on one
completely
occasion,
So
shut down.
please help out the municipal board.
on one occasion, this actually was actually contributed, which fell from your lordships on one occasion when I came before a coordinate bench. So they have assets, they can sell off the assets to pay off the debt, because we as such have got no role to play here.
Yes, no role, but then no
Just give a
parametric
grant in it.
provision. No
The
parametric
entire
provision like
district
town
will be
and county planning,
paralyzed.
where government can give. Oh, you had shown from section 50 itself.
50 itself. Because
Where? Section 50 itself?
section 50, your lordship, page 69,
Huh.
with regards to gratuity or pension, and then there is provident fund. So they have to create their own rules as such.
No, government can give grants, loans. Where is that?
Grants, your lordship, not here. In the municipal act is there. It is there, your lordship. I have to find out that particular section. It is there.
Okay. You have.
I think it's 46
There's
or
a
46.
municipal law to. Asam municipal act boli ase rakam. So try out, give if you have that enabling power to give loans and all.
Also,
So
only grant in aid is mentioned. I think it's 53 or 46. I'm confused with regards to the section. But it is there, your lordship.
Mr. Dhar, why didn't you pay for the in the year 2023? Then you had surplus.
Yes, my lord, that was not done actually because of some reasons. Probably the previous year's liabilities were
Hmm,
there.
maybe. Okay, Mr. Chaudhary, you make a representation before the Municipal Administration Authority by a forwarding letter of the municipal board, right? And in its power, the government will give you some grants and all. I'll write that the government to help out the
Your
board.
lordship, we have stated in the affidavit itself that there is no provision in the Assam Municipal Act to release the fund regarding this grant in aid to his employees.
Not like those Town and Country Planning Act.
No.
There is no provision.
There is no provision. So here we have written, the Director Municipal Administration is not responsible regarding payment of salary, leave encashment, benefit, retirement, etc. to the employees under jurisdiction of any municipal board, and there is no provision in the Assam Municipal Act to release the fund regarding the same. In this case, she would
No,
mean
for salary pension, no.
No.
For any grant aid, for those.
grant in aid, yes, of course, there is a
Where is
provision.
that provision?
That is, I'm just downloading it somehow.
Sonia, municipal law to nine.
Section 60 perhaps.
It just no pet to just. Charge na use kori charge na কি করলে আনছো some municipal law কি হল okay I'll dispose of this matter. I'll see what
Lordship may
directions-
dispose it of directing the Director of Municipal Administration to consider.
consider
To
yeah.
consider. Lordship.
In view, so if I could
And
get
after
hold of
speaking
the
of-
section,
Yes,
then I could have said, yes, take recourse to that and then give some money.
yes,
Let's
somehow
try to find out.
my network is not working properly. Lordship.
Section 59 perhaps, my lord.
So the
Section
municipal
59.
board cannot take the plea, lordship, that since we are not getting grants in it, that is why we cannot make the payment.
That plea is not taken up. That
No,
plea is
but
not taken up.
So now here,
We are
the
not-
pension is basically not being paid because there is shortage of fund. And now my learned friend has submitted that we do not have, we have asked for the grants in it from the state government. Since we are not getting that, now we cannot make the payment.
No,
That
it is their duty also to
that is
generate
why a
funds.
Detailed affidavit is required from there, and then how the funds are being utilized, lordship, maybe that might show because there are other.
No, that I will reflect it. Under the law, they have to generate their own funds.
Yes.
Like in 23, there was surplus. Then why deficit now?
Yes, and that,
So the management was wrong, perhaps.
just because the state is not providing grants in it does not give them a right that we cannot pay them. That is why there's a fund allotted. How the funds which they have generated, that is why a detailed affidavit from their end saying that how it has been utilized, that will bring some transparency.
Mr. Dhar is there, not required. Anyway, Dhar has also the responsibility to pay its employees.
Yes, lordship.
And then they will also give a try
Merely
and manage the board
Definitely.
properly.
because state grants in aid is not being provided, that is why we are not being able to pay the pension is, lordship.
Okay. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner, and Mr. A. Dhar, learned standing counsel for respondent number, learned standing counsel for
Four.
Karimganj Municipal Board, and Mr.
Now, my lord, Sribhumi Municipality.
Huh?
Now,
Sri
Sribhumi Municipality.
Now
Board.
Sri Bhumi, okay. Sri Bhumi, huh? The municipal board Sri Bhumi, and Mr. R. Bora,
D word.
D. Bora, learned standing counsel for
1 and 3.
1 and 3.
Not standing counsel, government advocate.
Oh, learned government advocate
One.
for representing respond number 1 and 3.
Lordship, I have a page for respondent number 2.
Acha, okay. And Mr. A. Choliha, learned standing counsel for the Department of Finance. By this application, the petitioner has sought for a direction from the respondent authorities to pay her the retiral benefits, to pay her the pension and other retiral benefits. Where is the prayer?
Page 910, my lord.
Benefits. Oh, take us. Give it to Mr. Bora. I have the act. Just
Yes,
look
yes.
into it.
I'll look into it.
Yes, huh? Along with the interest at the rate of 12% per annum till the amount is paid to the petitioner. আচ্ছা, না, এটা ঘট করে নাও। The case of the petitioner is that she worked as an LDA since the day she has joined, that is on 18/11/1996, and that she retired on 31/10/2021. And during the course of her service, she has received the salary as a regular employee. However, she submits that after her retirement, she did not get the pension or her retirement benefits. The Learned Counsel for the petitioner submits that respondent number 4, that is the municipal board, chairman of municipal board, had informed the petitioner by issuing a letter dated 9/12/2022, informing her to give the details of the retirement benefits due to her, which should be paid by the department. And in response to the said information, the petitioner has given the details of the retirement benefits to be paid to her.
Page 7, para 7, my lord. Page
Yes.
7, para 7. The details of amount.
She was paid something, right?
Yeah, paid during this petition, my lord, only 20,000 paid, my lord.
Achha.
So out of 12,48,969, now, my lord, 12,28,969.
Wait. Your paragraph 7 says that area salary, some
Yeah.
salary was also not paid.
No, right. My lord, total gratuity, leave salary, PF money, arrear salary. These are total amount. And these are not disputed also.
She further states that she came to know that the area salary was paid except for the month of October 2021. And she had calculated the amount that she should receive from the board and had given the same to the concerned authority. But she submits that till date, her pension as well as her pensionary benefits along with the arrear salary was not paid to her. Mr. Dhar, Learned Counsel appearing for the municipal board, submits that the chairman of the Sri Bhumi Municipal Board, by various letters to the Director of Municipal Administration, has requested for financial help for payment to its employees on various accounts. But the municipal administration is stated to have not helped the municipal board. He has further placed the auditor's report in connection with the municipal board, which shows that in completion of the financial year of 2023, there was a surplus amount, but thereafter, in each of the financial years, there were deficits. And because of these deficits, the board is not been able to pay even the salary of the present employees, of the existing employees working under the municipal board. On the other hand, Mr. Bora, the learned government advocate, submits that under the Assam Municipal Act, more specifically under Section 50 of the said Act, it is provided that the municipal board from time to time make rules, municipal board from time to time should make rules for gratuities and pensions to be granted and should generate its own funds to make payment to its employees, including the retired employees. He, however, submits that no rules or regulations has been framed by the municipal board till date. as required under Section 51 of the said Act. He as such submits that it is not the responsibility of the government in the municipal department to pay the salaries or the pension or the retirement benefits to the employees working under the municipal board.
Also, with regards to how the funds will be utilized, if suppose a grant in aid is given by the state government, how it is utilized, it is mentioned in section 53A. And if they are not properly utilized, then action can be taken against that particular board in terms of section 54. Next page.
Acha, no, where is the principal section on
53.
which?
53A, which
No,
says
that
grant in
government
aid.
grant
Now,
in aid.
funds basically.
53A.
53A. Under which heads it will be utilized. But not that grant in aid will be ever utilized for payment of salary or pension or anything or any retail benefits.
He further submits that under the Municipal Act, the government is only saddled with the responsibility to give grants in aid to the municipal board. However, under Section 53A of the said Act, the municipal municipal board has to account for the utilization.
Yes.
Provides that the municipal board has to account for
The funds which are
with respect to the funds allotted by the government in the shape of grants in aid, and that the said funds cannot be used for payment of salary or pension or similar other expenses by the board. Full stop, para. Although it is seen that the municipal boards has to generate its own funds for payment to its employees, as it is provided under 50, Section 50, subsection 3. However, there is a rider provided in the said section that the said payment of gratuities or pension requires approval of the state government. Further, under Section 50, subsection 1, it is provided that the board, from time to time, determine and appoint the establishment and will fix the salaries and allowances to be paid to such establishments. However, an amendment was brought into force to the said subsection in the year 2011, which provides that staffing pattern in the establishment has to be determined by the government from time to time. It is also provided by way of a proviso appended to the said section 50 that appointment of any officer or employee whose pay is wholly or partly contributed by the state government shall not be created or abolished without the sanction of the government. So the government has some role in even
That is
appointment.
only with regards to the CEO.
CEO.
In terms
Employee
of
also they say.
Section 50, 50.
No, 2011 there is an amendment saying even employee will be included, not only officer. So no, what I'm on is they have some role in staffing pattern as well as the payment to some employees.
Your Lordship, only whose pay is wholly or partly contributed by the state government
Yes.
shall not be created or abolished without the sanction of the state government. So here we are not paying even wholly or partly. We are not paying at all.
But it is provided you can.
Provided further that the appointment of any officer or employee whose pay is wholly or partly contributed by the state government shall not be created or abolished without the sanction of the state government. So we cannot give any sanction as such for something which you are not paying, either wholly or partly.
No, it's okay, yes. But then the power is there, so you have some role in the payment as well as staffing. So
Only the staffing
they-
pattern, your Lord.
Yeah, staffing.
Staffing
So consider their.
we can only consider whether
This is what.
anything retirement benefit can be paid, your Lordship.
So this provision show that the government has some role both in the staffing pattern as well as payment to be made to certain employee or officer. It is also seen that the regulations has not been framed by the municipal board. It is also a subtle position of law that the employee having given their having served an institution should be paid for such work. Non-payment to such employee would be in violation of Article 21 of the Constitution of India. The said analogy will also be applicable in case of pension and other pensionary benefits, including gratuities. It is the case of the petitioner that since the date of her retirement, her retirement in the year 2021, and now it is 2026, that she has not got a penny towards pension and other pensionary benefits.
No, she has got, your Lordship.
No.
Oh yes, during the pendency she got something.
Yes, yes.
She got only 20,000, my lord. Only
She-
20,000.
Somewhat.
and কি করলো? Till 2026 she got
20,000
no,
rupees.
she got it is now 2026 করলো না? She got only 20,000 rupees towards her entitlement for pension and pensionary benefits. And her entitlement was to the tune of rupees 12,28,969. The said amount is an admitted amount to be given to her acknowledged by the respondents. As such, for protection of the fundamental rights and human rights of the petitioner, this court directs the petitioner to make a representation before the Municipal Administration Authority. What do you say?
Director of Municipal Administration.
Or Director of Municipal Administration.
Respond number 3.
Respondent number, Director of Municipal Administration. Along with her. Forwarding letter by the chairman of the municipal board for consideration of the payment of her pension and pensionary benefits by the state government in the municipal department. It is further directed that the municipal administration department, the authorities in the municipal administration department, should consider the case of the petitioner. And since they have an enabling power to give grants in aid as well as loans to its wings, it's a wing, right? To its wings. It's a wing, the municipal, to its wings, such as the municipal board. The same may be considered in the present case. It is also directed that the Director of Municipal Administration would dispose of the representation submitted by the petitioner within a period of 2 months from the date of the receipt of the certified copy. Okay? You consider, since you have power. Yes, Mr. Chaudhary, nothing more than that.
Mine.
Okay.
Obliged.
Obliged.
Okay, Mr. Dhar.
No.
Petition is disposed of. Item? Orders, I know. Yes, why orders?
Orders because the last order was passed by the, as per official dated 29/5/2026. The service upon respondent number 7 has been completed on 10/11/2025. And
AD card received back from respondent number 7.
and 6 is.
But 6 is not served.
Yes, madam, it's a commissioner of Panchayat, madam.
So 6, any representation? 6, 7? No, no?
No, Lordship, Lordship, although it has already been complied with. Let me just.
Oh, okay. Your claim is done.
I have no instruction, madam.
The direction was to verify is the records and say whether he is entitled to pension or anything. It has been decided that since there was from the date of absorption to the date of his death, there was no 1-year continuous service. So as per the scheme, he is not entitled to any pension. Although GIS and leave encashment benefits are already been sanctioned to the petitioner.
The direction is there, my lord, of this honorable.
Lordship, may I peruse the last page.
So if you are not entitled, what can be last page? Here?
Yes,
Uttar
Lordship.
side.
Yes, opposite side.
Runu Kolita is the petitioner.
Lordship.
It was given to her as well. So why don't you have the instruction?
Let's check, my lord, first. I take instruction from.
1 second. Appointed as driver at block under DRDA. Driver, driver, no. 17. Yes, so he was regularized or absorbed in August 2017 and he died next year, June 2018. So he has not completed 1 year of regularized service, regular service. So he is not, otherwise leave encashment and all were given, GIS insurance fund also. But compassionate family pension to you are not entitled.
To check because he was also suffering from cancer, whether there is any special one.
Okay, let him take in. Okay. Mr.
And Sarkar.
N. Sarkar, learned counsel for the petitioner. And heard Mr. Resekaram and Mr.
A.K. Ghosh on
A.K. Ghosh, I always forget. A.K. Ghosh on behalf of Mr.
S. Datta.
Mr.
S. Datta for
S.
respondent 1.
Datta, learned counsel for
Respondent number 1.
respond number 1. Mr. Ghosh has pleased, and Mr.
I'm appearing for respondent with me on behalf.
On behalf of? D Nat. Okay. You're Mr. R. Saha. R. Sanan. You give your name, huh? Appearing on behalf of Mr. D Nat, huh? Uh, Mr. Ghosh has placed an instruction which says that the petitioner's husband died on 16/6/2018 and that he was absorbed as a government employee only on 1/8/2017. So the petitioner had not completed 1 year of regular service in his post. As such, although the leave encashment benefit along with GIS insurance fund has been sanctioned, but compassionate family pension could not be sanctioned because of the said impediment. Mr. Sarkar, however, submits that he wants some time to go through the instruction and have a discussion and go through the instruction. Prayer is allowed. List this matter when? List this matter on 17th of June, Wednesday. Acha, are you giving this copy or you have?
No, you can.
Acha, the instruction is made part of the records. Yes, Mr. Decker.
No, it's an uncompliant. 8/8/2020.
He has something to say.
May I please, Your Lordship?
Yes.
My senior, due to the medical emergency, he went back to his home. Kindly pass over for the.
Some other day. Your senior is?
B. Kaushik, madam.
Oh, Vedanta Kaushik. Acha. Learned counsel, your name please?
P. Lamu.
P.
Lamu.
Kamru, huh? Appearing
Lamu.
on behalf of Mr. B. Kaushik.
For the
Submit
respondent 1 and 2.
that Mr. Kaushik had some medical emergency and had to leave the court and has prayed for some time. And as such has prayed for some time. Prayer is allowed. Please this matter.
Next Thursday, my lord.
Please this matter
11th.
on 11th of June.
Once open.
Give your blessing.
Please, Lordship,
Mm.
in terms of last thing that I'll submit the compliance report, Lordship.
Yes, compliance report, contempt case.
Yes, Lordship. Lordship, as per the last direction, I've brought my compliance order, my lord. Dara.
This is for what purpose? Where is the direction?
Portion of the order, Lordship, page 20, Lordship.
Lordship, page 20.
Paragraph 23, my lord. For the reasons stated.
Case of the writ petitioner for promotion to the post of JAA.
Junior Administrative Assistant.
Acha.
Promotion, Lordship.
By extending similar consideration as has been done in the case of Gajendra Kumar Ray.
Exactly.
Light of the judgment dated so and so passed by this court. The excess.
That is completed within a period of 4 weeks from.
So
the date of
promotion given.
So Lordship,
promotion method.
Lordship will kindly come to page, paragraph 23. The paragraph 23 reads that for the reasons stated herein above, the writ petition succeeds and is accordingly allowed. The respond number 1 and 4 are directed to consider, my lord, to consider.
To consider and reject.
The case, to consider
What you
the
mean is
case of the petitioner, my
consider
lord.
and reject.
No, my lord. I'll come to it, my lord. I'll come to it. Consider the case of the petitioner, writ petitioner for promotion to the post of JA by extending similar consideration as has been done in the case of Gajendra Ray in the light of the judgment order dated so and so. Now, Lordship will kindly come to the order which I have furnished to you. The order which I have furnished to you, my lord. Lordship, as per this order, peruse the order of the Honorable High Court dated 15/6/23.
What is this? Is 17/6? No, what?
Order, it is, Lordship, my order in Lordship,
15/6, yeah.
15/6, I think.
2020.
Yes, my lord. I have 15/6/23, my lord. So and so, my lord. Also peruse
One
the letter
second,
dated 22/6/23. My lord, the main content of the case of this so and so, my lord, peruse the relevant records. From the records, it is found that the petitioner was initially appointed at so and so, so and so, so and so. as per available records, the petitioner was allowed to appear, my lord. So there was a complete.
I'll read it myself.
My lord, my lord. So,
This is, he is Dinesh Kumar Singh.
exactly, ma'am. Dinesh, ma'am.
Acha, so he did not qualify in the computer.
Exactly, my lord. So he was given a chance. He was given a chance.
An active court order.
No, no, my lord.
Because that order was passed on 15/6/23, wherein clearly directed to consider a promotion lord.
Exactly, my lord.
Now they have passed on subsequent order. Can they override that active order? Lord?
Acha, no, with this order, by extending similar consideration, which is
Exactly, my lord.
Gajendra Kumar Ray.
Exactly.
He got promotion lord.
He got, because my lord, he has got the necessary qualification, my lord.
There is no
So, my lord,
sit in the examination lordship.
my lord.
Clearly directed to give promotion similar
No, no, my
to
lord.
person like him.
If lordship, kindly come to pay the
Lordship, let them file affidavit.
No, no, I will not file, my lord. My lord, lordship, kindly come to page paragraph.
Wait, don't fight it.
My lord, kindly come to paragraph 23 once. No, it'll be, let us be clear, my lord, first. I'll file my affidavit, my lord, but let us be clear first. What is the order which has to be complied with?
Yes,
You
yes,
cannot just say anything, my lord.
Writ petition succeeds and accordingly allowed.
Yes, my lord. No, no,
To
he's only on succeed,
consider
my lord.
the case.
I am also, I am not disputing that. Kindly see paragraph 23. For the reasons stated here and above, the writ petition succeeds and is accordingly allowed. So his case is to be considered. So the court directed that you look into the matter, scrutiny, give him the thing. So as lordship will kindly come to now, lordship will kindly come to the instruction which I've given to you, lordship. That instructions, my lord, your lordship will kindly see the last part. There's an act there, my lord. And that is the Article 309 backed rule, my lord. By the Article 309 backed rule, it's a statutory rule, my lord. We have to follow that, my lord. He has not challenged the rule, my lord. The rule is there, my lord.
He's submitting lordship. In the prior lordship, my case was promotion. So how I challenge?
So, my lord, no, my lord. Kindly come to the rule, my lord. Kindly come to the rule. Kindly come. There is a rule, my lord, in the thing, my lord, on the last page, my lord. Yes, my lord. Amendment of Rule 18, my lord, of 4, my lord. It's given here in the principal rules, my lord, in Rule 18, in sub Rule 3, in clause B for existing second paragraph, so and so, the candidate for the post of junior administrative assistant must possess knowledge of computer as specified below. He must have working knowledge of office productivity, software tools, independent of any operating system, that is MS, Windows, Linux, Mac, etc., such as word processor, so and so and so and so, A, B, C, D, E, F, all these, my lord. So, my lord, his case was considered, my lord, since he had, since the writ petition was allowed, my lord. The honorable court had directed us, my lord, to consider his case, my lord, and accordingly we have considered his case. On 5/10/24, my lord, he was called for the proficiency test, my lord. He has applied and he has participated in that test, my lord. After participating in test, my lord, he has not qualified for that test, my lord, and accordingly we have passed a reasoned order, my lord, to that effect.
Lordship, in a contempt case, he's arguing in one merit lordship.
I'm not arguing a merit, my lord.
He'll submit whether he will comply or not, lordship. That is lordship.
Yes, my lord, I have complied, my lord. I have given the compliance order.
Lordship,
I have given the compliance order as per paragraph 23, my lord.
No, yes, of course, there is a direction.
Yes,
but direction was not to appoint.
Exactly.
To consider the case of the writ petitioner for promotion to the post of JAA. So that, of course, will not mean that you override the rules and do it.
Lordship.
Rules were in force in 2017. Amendment was brought in effect.
But there
Which-
was no such direction to appear in the examination lordship. Court directed to promote him lordship, like similar situated person. Lordship, let them
Not
file.
directed to promote him to consider. I mean, during that writ proceedings, this act was not placed.
He has to place, my lord. He has not
Lordship,
placed.
that is on record.
He has not placed, my lord. He has not placed, my lord. It's a contempt case
No,
now.
lordship, he is submitting false submission.
And my lord,
Lordship,
writ
let them
petition,
file
my lord,
for-
writ petition, my lord, writ petition has been allowed, my lord. That is undisputed. Writ petition has been allowed. I agree with him, my lord. And in the writ petition, it was directed to us, my lord, that basically you consider his case. like in the other cases. So accordingly, my lord, he was called for the professions because the rule itself speaks for itself, my lord. There, my lord, to become a junior administrative assistant, my lord, one has to have this thing, my lord. I'm not submitting beyond my instructions, my lord.
So, okay, you file an affidavit there.
Lordship, let him file.
Then, my lord, I'll.
Because otherwise, I don't see that.
Can be closed, my lord, actually.
No,
Let him,
Lordship,
let him challenge this, my lord.
Lordship,
He can
this is
challenge this order.
2022, Lordship. No affidavit has been filed, Lordship. Let them file of that affidavit, Lordship.
My lord, let him challenge this, my lord. He can challenge this always.
Let him.
He's always got the liberty to challenge, my lord. No one can stop him, my lord. And technically speaking, my lord, if your lordship sees the paragraph 23 of the order, and your lordship sees, let me complete.
Lordship, whatever he's submitting, Lordship, that is also not in my hand, Lordship. I have to take an instruction, Lordship. Just now he is placing, Lordship.
My lord, I have received it now. It's a between.
Okay, okay, don't fight. We'll
My lord,
take
I'm not
it
fighting,
up.
my lord. He's, my lord.
Heard Mr.
R.K. Talukdar.
R.K. Talukdar, learned counsel for the petitioner, and Mr. A. Fukon, learned standing counsel for Elementary Education Department. This contempt application is filed for alleged violation of the order dated 15/6/2023, by which this court had ordered the respondent authorities to consider the case of the writ petitioner for promotion to the post of JAA by extending similar consideration as has been done to a similarly situated person. Today, when the matter is taken up, Mr. A. Fukon has placed an instruction which shows.
My lord, compliance order, man. Order. It's an order, my lord.
Oh, yes.
It's an order.
Placed an order dated 4/6/2026, by which it is reflected that in compliance of the said judgment and order, the petitioner was, the petitioner was allowed to appear in the this order, which reflected that for promotion to the post of JAA, Junior Administrative Assistant, an employee has to be proficient in computer application as per Rule 8.3 of the Assam Secretariat Subordinate Service Rules 1963. And that the petitioner, full stop karo. The petitioner was as such allowed to appear in the computer proficiency test held on 5/10/2024. And that he did not qualify in the said test. And so his promotion to the post of JAA was rejected. Mr. Talukdar, learned counsel for the petitioner, submits that he had that he has to go through the said order and has prayed for some time. Prayer is allowed. In the meantime, Mr. A. Fukon is also directed to file an affidavit.
I'll bring it on record, man.
File an affidavit for bringing into record the said order as well as the rules connected in the instant case, as well as the rules relevant in the instant case. List this matter on before vacation.
Yes.
List this matter on 23rd of June.
Deeply obliged, man.
Before I pay for little accommodation, file is before the MSL also. File is before the MSL. File is pending before the MSL also. So little.
MSA is?
Ministry of Home Affairs also.
MHA. Okay. Mr. K. Gogoi, learned government advocate.
No, no.
Learned
CGC.
learned CGC. CGC. Learned CGC prays for a short accommodation. Prayer is allowed. List this matter when?
After 2 weeks, Lord, after 2 weeks.
List this matter after 2 weeks. Actually, it is the last week before vacation.
Then
Perhaps it will
immediately
be
after
mush.
vacation, immediately after vacation.
List this matter
Vacation will be good.
on 15th of July.
Lordship.
Lordship, in the earlier, in the matter relating to Municipal Act, Your Lordship, I forgot to mention, section 58 deals with municipal fund. with
Section
grant
58.
58 and 60.
Apologies.
Your Lordship may observe 58 and 60.
वो आपने लिया था क्या? नहीं ना? अच्छा, okay. 58 and 60. এখন কিতাপ মোক দি দিবাচোন চেম্বাৰ এই মিউনিচিপাল এখন হয় নি যিকোনো এখন দিলে yes yes Mr.
Lordship, here in this case, I was instructed to obtain necessary instruction, and I have received the instruction, that is the order, by which the disability pension, the prayer for disability pension has been rejected by the concerned authority, Lordship. I'm just placing this before this honorable court.
The order passed by this honorable.
Contempt case again it is
Contempt case.
rejected.
Yes.
So kindly see the order. Page 9, my lord, last.
Page 9.
Yes, bottom at the bottom. In view of the above, the writ petition is hereby disposed of at the motion stage by providing that the claim of the petitioner for grant of disability pension be processed as expeditiously as possible by including the same in the next phase of claim. An attempt to be made to disperse the amount payable to the petitioner within a period of 6 months along with the area, if any. The writ petition stand disposed of. Before that, my lord, they are saying, kindly before that, in this case, my lord, they are saying that, kindly see, my lord, before that, petitioner was entitled to disability pension whose prayer has not been considered.
Where is that?
My lord, upper portion,
In the same page.
same page, my lord.
He is otherwise not eligible under the CCS rules, Lordship.
My lord,
That communication has been given by an officer without going through the relevant provision of the CCS rules. So accordingly, your Lordship, kindly see this communication.
See here,
Yes.
like in the other case, it was consideration.
yes,
Yes.
Here it is not that. Here by providing that a claim of the petitioner for grant of pension be processed.
Yes. On the basis of a
For
communication.
grant of, for consideration for.
No, Lordship, this particular order has been passed in the motion stage because of one communication that was there. The petitioner placed one communication. In view of that communication, taking note of that particular communication, that order was passed. And even in this particular order, which has been there, just making the observation that it has been violated. In this particular order, it has been specifically mentioned, subject to whether this is permissible or not. Because as per the CCS rules, this petitioner is not entitled for that disability pension. So it has been properly assessed and accordingly.
But that should have been pointed out before the writ court.
No, that communication was there. The petitioner was relying on a particular communication. The person who has issued that communication with regard to the fact that the petitioner is entitled for disability pension, he has not taken note of all the relevant provisions. And thereafter, when the order has been passed, we have taken note of these relevant provision of the CCS rules.
The filer reviewed it.
Lordship can take note of this particular communication. I will place it in the form of an affidavit. If your Lordship pleases to consider that whether it has this particular order has been passed in compliance with the direction of this honorable court, because the inconvenience on the part of the authority is that Lordship, as per the CCS rules, the pension cannot be granted to the petitioner.
my lord, as per disability pension, he is entitled, my lord.
You do one thing, you file a review against this order.
And kindly see 9/1/26.
Because
order.
now here the order is you process it. No ifs and buts. You process his case and grant him as soon as possible. Now you are saying that he is not entitled under the CCS rules.
Because the communication that was placed before this honorable court, based on that communication, the order was passed.
What
Because on the,
it
at the
is,
very, very.
it's passed, you
Yes.
pointed out all this.
That
Because
is part of the petition, my lord. That communication was a part of the writ petition.
Ah,
At
yes.
that point of time.
You should have pointed out before.
At the motion stage, Lordship, this order was passed.
So what?
My lord, because.
At the,
You were heard, your counsel.
no,
was
I'm
there.
not on that, Lordship, but subsequently this communication.
You were there.
Yes, I was there.
SP Chaudhary.
Exactly.
So,
I was there. I'm not saying that I was not there, but the fact is that, Lordship, this particular communication
Hmm.
that was issued without taking note of the relevant provisions of the CCS EOP rules, Lordship. So that was the difficulty. That's why this particular communication has been.
these
Yeah.
are to be married, you should have pointed out before the writ court, you have not filed review. Now you say that and law is not being followed. Now she cannot be given.
Lordship,
This is too much.
Lordship, kindly give us 2 weeks time. In the meantime, I will place this communication before this honorable court, and if I get the necessary instruction, I'll prefer a review petition.
Kindly see 9/1/26 order. Kindly see.
Where is that?
9/1 order, my
Oh,
lord.
acha.
I'll do now.
Compliance report. Then again on 18/5/2026, And he's a old person. He retired in 1991, my lord. He was discharged on medical ground. So he is entitled for disability pension.
This is not a compliance order.
No, I'm not saying about the compliance, lordship. What I'm submitting, that we are saying that he is otherwise not eligible for the disability pension. I'm just placing this particular affidavit, this communication in the form of affidavit. Lordship may please us to pass any order thereafter, lordship.
He's not filed, if he is not filed, it appeal now at this stage,
No,
my lord.
I am just placing this order because on the last occasion, lordship has, lordship kindly see on the last occasion, there is a direction of this honorable court. Because I had made a mention before this honorable court that we have rejected the claim of the petitioner. So there is a direction to place it before this honorable court. Pursuant to that direction, I am just placing it before this honorable court.
You file an affidavit, we will
Yes,
decide.
lordship. I'm filing an affidavit.
Mr. S.P. Chaudhary,
Yes.
counsel for the petitioner, Miss Smith,
Bora.
S. Bora, heard Miss S. Bora, learned counsel for the petitioner, and Mr. S.P. Chaudhary, learned counsel for the respondent. By this application, the petitioner has alleged willful violation willful violation of the order dated 18/11/2024, by which this court had directed that the claim of the petitioner for grant of disability pension be processed as expeditiously as possible by including the same in the next batch of claims. And it was also directed that an attempt should be made to disburse the amount within a period of 6 months. When the matter is called up today, Mr. S.P. Chaudhary has placed a communication by which it is reflected that the petitioner's case could not be acceded to on the ground that it results in violation of
Rule
the
3
CCS rules.
CCS EOP rules, lordship.
CCS?
EOP, extraordinary pension rules.
Yes or no? Rules.
Just first paragraph, lordship. First paragraph, lordship.
Of this page.
Yes.
CCS within bracket pension rules, 1972, and CCS within bracket EOP rules 1939. However, the same cannot be entertained at this stage, more so in view of no challenge being made, more so in view of the said provision, the said impediment was neither placed before the writ court nor any appeal or review is filed. And the writ court's direction was clear to process the claim of the petitioner for grant of disability pension. However, Mr. S.P. Chaudhary submits that he will file an affidavit incorporating the said instructions or any other and has prayed for some time. Prayer is allowed. List this matter on 22nd of June. You can do it
Yes.
within 2 weeks? Yes. Second.
Always, lordship.
Mr. 2 times we have taken the steps.
Contempt case.
Yes, contempt.
1, 2, and 4. 3 is served.
No, madam.
Response number 3 is served.
No.
Huh?
4 refused to accept this notice, my lord, as part of question of 29/5/26.
Mm-hmm.
4 refused to accept.
4.
Yes. So no ATM, no unsought notice has been received back from 1 to 3, my lord.
Unserved notice returned from
1
4.
to 3.
1 to 3 could not be served. Who are these officials? Conservator of Forest,
Yes.
Forest Department, Range Officer.
Not only them,
Heard Mr.
L. Deca.
L. Deca, learned counsel for the petitioner. By the office note, it is reflected that service of notice on respondent number 1 return back with the stipulation that service could not be done. And as far as respondent number 1, 2, 3 and concerned, there was no report of service.
4, my lord, refused.
Refuse is not there.
Yeah,
Notice
the
return
office
back.
note is there. The office note it is there.
No, unserved notice return back from so oh acha is
That's
refused.
my lord.
Okay. क्या बोला पहले बोला था? As refused करके लिख दो ना. Notice could not be served with the postal remark refused. It is seen that steps were taken a number of times. As such, the petitioner is directed to inform the Standing Council of Forest Department. No, to approach the Standing Council of Forest Department with the request to serve the notice upon the said respondents. If you can do through him. List this matter again on after vacation. 25 contempt case. I have seen contempt case lying for so many years. Okay, list this matter on 23rd of June.
Yes. Non-payment of pensionary benefit.
So, pleadings complete.
Last occasion, my lord, respondent number 6 and 7 were appeared. I took the service, my lord. Until today, they have not filed any affidavit. But they 5 and 6 from.
May it please your lordship. Lordship, with respect to respondent number 3 and 4, lordship, that is the people holding the post BDC, lordship. They have processed the pension, your lordship. We have already intimated the state government. So, lordship, with all due respect, the respondent numbers 3 and 4 have complied with the court of the honorable or the order of the honorable court.
Where is the order, Ms. Devi?
Order is lordship.
Respondent has filed. Respondent number 6 has filed affidavit.
Number 6 file and 3 and 4, 3 and 4. 3 and 4, madam. They said that they have complied, madam. But until today, I have not received anything, madam.
Lordship.
What is going on, madam? Very unfortunate.
Very unfortunate.
Yes, madam. They have supplied us to copy so
Lordship.
that I can go through it before that.
Lordship,
So
I have
need to
received it
submit,
today
madam,
itself.
on behalf of that.
And this contempt application is very unfortunate. I mean, there are orders and they do not.
My lord, the pensionary benefit, court has passed an order to supply, to provide pension and under the Act of 1969. Then I have to file, my lord, contempt against them. He has already been retired.
No, where is
He's
the
supplying
order?
lots, my lord.
Where is the order?
His lordship kindly, page same.
Operative portion?
My lord,
15.
there is a long, In this case, my lord, the petitioner was elected in the year 1991. Then there is, and his serial number is 17, my lord. Then pick and choose manner, he couldn't appoint, my lord. Then under the name of the petitioner, they were appointed. Then they approached before this, he approached before this honorable court. Honorable court passed an order to provide, to regularize the service of the petitioner. Then, my lord, he was appointed 2004, but he could not join because the post which was he was appointed, it was a transfer post, so he couldn't join. Then again, he joined in the year 2006. In the meantime, 2005 NPS provision is there. So they have stated that I won't be able to get the pension since I was selected in the year 1991, and I should appoint before the 5.
But because of pick and choose manner, my lord, that is, it is reflected, my lord. in the
I can see this here.
Yes.
What is your instruction, Mr. Sharma?
Lordship, the direction is that paid, Lordship.
I have not received the instruction yet, my lord, but the state has already filed an appeal, my lord. So, my lord, some time may be granted.
Appeal against this order.
Yes, madam.
What happened today?
Oh, I don't know.
Pending or what?
Give me the number then.
So, no, my lord.
If there is any mistake, then-
Objection is here for delay condonation petition. Sometime maybe, and its filing number is.
So delay is not condoned.
Yes, my lord. Filing number is 211.
Filing number, there is no stay order. Why you submit like this? There is no
So,
stay
madam,
order.
some time may be granted so that I can get the instruction.
The person who is suffering, my lord, 3 years before he was retired, till today he did not get anything, my lord. At least they should think over it.
They are not giving you under the new scheme also.
No, my lord. Like you won't be able to take, my lord, because you will get the old pension scheme. 1969. And there is an order passed by this honorable court that case also, provided that the person who is
He is entitled under
elected,
1969.
yes, elected in the year 1991, they will get the, because of PKM choose manner, the petitioner was appointed 2006, my lord. Otherwise,
matter
he
of
would
the-
have not been come before this court, my lord.
Acha, what does the instruction say? The matter of the petitioner is OPS. OPS means
Lordship,
whole pension scheme instead of NPS related
NPS,
to
yes.
the related.
if Lordship
pension.
peruses the second,
Acha, so it does not come within the BTC.
Lordship, the second and third page, Lordship. So the direction was that the respondents are accordingly directed to forthwith process the case of the petitioner for giving pensionary benefits. Now, with respect to respondent number 3 and 4, Lordship, considering the fact that pension is not an entrusted subject to BTC, Lordship, what we do is that we process it and we forward it to the state government. And as per the second and third page of the instruction which I have provided, Lordship, we have duly processed it and forwarded in the due course of time. This order was of Lordship perhaps February 2025.
They will
Okay, so-
Yes, Your Lordship, that was due to a miscommunication,
Yeah.
whatever. And
Okay,
within
Mr.
2 months,
U.
Lordship, we have
PM
complied.
U. Sharma.
Stay order, my lord, from this court. Otherwise,
There
how
is
can
no,
we
even the
submit?
delay is not condoned. So you file an affidavit. Have you filed an affidavit?
No, ma'am. So 2 weeks may be.
So they are setting their hands off. They say that this is not a transfer subject, it is for the state government to decide.
Yes.
Okay. So you file an affidavit bringing the instructions on record. But then not later. This is see, person is not getting pension, although there is a clear-cut order that had he joined before, by virtue of the select list, then he would have got the pension under the old pension scheme. Just because somebody else was appointed in his place, that too, wrongly, that will not disentitle him. Third, Ms. K. Devi, learned counsel for the petitioner, and Mr. U. Sharma, learned standing counsel for
Only number 1 and.
secondary,
Yes, ma'am.
secondary education, and Mr. V. Sharma,
NR Sharma, Lordship.
N.R. Sharma, learned counsel for the BTC,
Respond number 3 and 4, Lordship. 3 and
representing respond number 3 and 4. And Mr. A. Choliha for respondent number 6. The Mr. Sharma has placed an instruction wherein it states that the pension being not a transferred subject, the payment of the pension is left to the Director of Education, where payment to the state government.
Lordship, yes.
To
And
the
we
state
have
government.
forwarded the same to the state government.
And that, this one, last letter.
Lordship, yes, the
And
second
that-
and the third letter, Lordship.
This is by Inspector of Schools, Mushalpur. I think third one.
Lordship, the second one, if Lordship goes to the bottom, the copy to the second page, let's
Acha.
forward it to the Secretary, the Education Department. Lordship.
So he क्या बोला? Not being a transfer subject is left to the state government. Full stop. He has also placed a letter written by the Inspector of Schools to the Director of to the Director of Education BTC, Kokrajhar, wherein it was stated that the petitioners that the petitioner has claimed for pensionary benefits and that he was working as a teacher in Bhojkuchi High School, and that he has retired after completing his tenure. The said letter was, a copy of the said letter was given to the Director of Secondary Education, Assam. However, Mr. U. Sharma, learned standing counsel for secondary education, makes a prayer that he should be allowed some time to file the affidavit. It cannot be lost sight of the fact that the order whose violation is alleged was of the year 2020, and since then the petitioner has not got his salary.
Pension.
Has not got his pension. As such, the respondent number, the secondary education department is given only 1 week's time to file the affidavit. See, this is 2020 order.
2025. 25 to 2025.
Order is 25.
Order is 20, I saw.
25 to
WPC is of 2000.
page 10.
Page 10. Oh, no.
25 to 2020.
He choro, lost sight of the fact choro. As such, you Sharma bola na. As such, the prayer is allowed. List this matter on 24th of June. Yes, Ms. Dev.
This is a litigation which was dismissed for default on 10/11/2025.
Now you are filing for restoration.
No, I have also filed that condonation petition that was condoned lordship last occasion. Now I have
Condonation application to file the
Along with
restoration application.
yes, lordship.
Achha.
Yes, that was
Okay.
condoned lordship.
Okay.
And now restoration petition that was listed on 10/11/25 lordship. Without showing my name, I have filed a Bhokalatnama on 25/9/2025 along with one additional affidavit lordship. But after searching that, there was no Bhokalatnama, but the additional affidavit is in the record lordship. That is why there is no fault on my part lordship.
Okay.
On the
Heard Ms. M. Dev, learned counsel for the petitioner. This miscellaneous application, not IA, miscellaneous application, miscellaneous.
Yes, nowadays that is miscellaneous application.
Oh, nowadays again reverted back to the earlier.
Yes.
This miscellaneous case has been filed for restoration of writ petition number 5417 of 2023, which was dismissed for non-prosecution on 10/11/2025. The Ms. Dev submits that when the writ petition was listed on the said date, the name of the counsel appearing for the writ petitioner was not mentioned in the cause list. Although it is stated that both wakalatnama and additional affidavit was filed by the petitioner through the learned counsel. However, she also submits that Wakalatnama was not found in the file, but the additional affidavit was there, filed by the learned counsel for the petitioner. She as such submits that on the day when the matter was listed, that is on 10/11/2025, the learned counsel could not appear since she had not found that the matter was listed on that day. On the facts and circumstances, on the relevant facts and circumstances, this court deems it fit to restore the writ petition being WPC number 5417 of 2023 to file in the interest of justice. The miscase is disposed of. Registry to list the connected writ petition, which is restored for admission on the next date.
After vacation.
Writ petition on 22nd of July.
From 22nd to
Okay.
28th
On
and
16th of July. Or 15th of July, Wednesday.
Yes. All right.
Service is awarded for respondent number 1.
My lord, here in this case, the department has preferred an appeal, my lord, and stay granted.
Stay is granted. Okay, need not, it's okay. I believe what you say. Okay. And what about contender number 1? Narayan Kaur.
My lord, for Narayan Kaur, I'll inform the department, my lord, that we have not received the actually Wakalatnama. I'll inform.
Okay, we will wait till the appeal gets disposed of. Heard Miss Smith,
Sorry.
P. Sahoria, learned counsel for the petitioner, and Mr. S.C. Das.
S. Das, my lord.
S. Das, learned.
Pending counsel heritation, I'll be appearing for 2, my lord.
Learned counsel for respondent number 2. For respondent number 2. Mr. Das submits that an appeal is preferred against the judgment and order dated against the judgment and order whose violation is alleged by the petitioner in the instant contempt petition. He further submits that by order dated 22/5/2026, passed in writ appeal number 165 of 2026, the Honorable Division Bench had stayed the operation of the judgment as such. The learned counsel appearing for the petitioner submits that the instant contempt application be taken on a later date. Prayer is allowed. List this matter after the vacation on a date to be fixed by the registry.
Contempt application.
Notice, Mr. Ghosh appears. For which respondent you are appearing?
2.
Respondent number 2. What about MS Manivaran? There are 6 respondents. You are appearing for only 2.
Only for 2, Lordship.
You are for 3. This is contempt application, Mr.
Yes, lord.
Respondent number 3. What about other respondents? District Commissioner, Chief Executive Officer. Steps taken, Mr. Counsel?
I have taken step.
Notice issued to container 1 to 6 by speed post. But no report. Oh, yes. Learning about, okay. Heard, Mr. M. Sahoria.
M. Sarkari.
M. Sakia, learned counsel for the petitioner. by the office note dated 6/3/6/26, it is reflected that service upon respondent number 1, 4, 5, and 6 is not complete. However, Mr.
A.K. Ghosh.
A.K. Ghosh, learned counsel, appears for respondent number 2, and Mr. A. Choliha, learned counsel, appears for respondent number 3. Further, await service report in with regard to respondent number 1, 4, 5, and 6. List this matter again on 25th of June. 6th of June. Yes. Notice has gone. 5. 5 is represented by Pavitra Sakya.
My lord.
You appear.
My lord.
What about 1 and 1,
lord,
2?
Two.
So many.
My lord, there is an instruction from the two, my lord. He has no longer in this post, my lord.
Huh?
Santanu P. Gutmare, my lord, he is no longer in the post, my lord.
You have to again implead.
My lord.
With time, your area of respondents gets longer. What to do? So you are learning 3, 4, 5, 3, 4, 6 are represented. 5 is also 3, 4, 5, 6 done. 1, 2, 1, 2 is awaited or what?
One, we have received the power, but we haven't filed it yet. We'll file it.
1 you are appearing. So 2?
2 need to be impleted, my lord. Because
No. 2 has retired or what you say transferred.
Transferred.
Respondent number 2 is transferred. You have to implead the new incumbent. Okay. Heard, miss? K? A Khatun. Learned counsel for the petitioner. It is seen that, as far as the service of notice upon the respondents is concerned, it is seen that Mr. P. Saikya appears for respond number
5, my lord.
5.
5, my lord. True also, my lord, personally communicated me, my lord. There is a letter.
Yes.
He said that he is no longer in the post. There is a communication, my lord.
And who appears for 3, 4, and 6? You. Mr. A. Choliha appears for respondent number 3.
1 and 2.
1 and 2. Mr. A.K. Ghosh for respondent number 1 and 2.
No, which is 4.
1, 2, and 4.
1 and 4.
1 and 4. 5?
5, my lord, I may be.
I've already said.
My lord.
So 1, 4, 5, and 3. 3 you are appearing. So who else is left? 2.
1 and 2.
No, 1 is appearing.
Which is
2.
2.
2.
2, my lord, he has transferred.
2 is who? Oh, he has retired, you said.
No, he has transferred, my lord.
It is stated that respondent number 2 has been transferred
My lord.
to other district or what? Has been transferred,
My lord,
and in his place, new incumbent has joined.
No.
As such, the learned counsel for the petitioner seeks permission to implead the new incumbent as respondent, and that she would file the impleadment application. List the matter again on when? List this matter again on 13th of July.
No, sir.
Mr. A. Fukon, Ornav Nohani. Mr. Fukon, yes. You have filed this IA for what?
This IA has been filed by me, my lord. Basically, my lord, on 8/5, my lord, we were supposed to file an affidavit. Honorable Court had directed us to file an affidavit. We have basically filed it, but it was, my lord, because of some reason, it was defective. And my lord, I had to again, basically, my lord, get my full instruction and get it sorted out.
You removed the defect and...
No, I took it out because there was some mistake, my lord. And then I had to take it out. So then what happened, my lord? We did not see that, my lord. It was that on or before 8/5. Because it was on or before 8/5, I had to recall the thing. So, my lord, my affidavit was basically, I could not file it. So I filed it on the day, just the next date, the date which was, it was this. Because of that, I could not file. So the Honorable Court also said that, it's a direction which has already been passed. So you have to, you better file an IA and pray for basically dispensing the order of 25,000. So accordingly, on the last date, if Lordship checks the last order, the order.
In the IA?
Yes, my lord. The IA, the Honorable Court has allowed me to file the affidavit. So the affidavit is filed without paying the cost. So now my lord will allow this IA, and my lord, the main case can be taken up on some other day, ma'am. Because if your lordship kindly see the last order of the IA,
Okay.
it's allowed, my lord. We have been the 25,000 has been dispensed. Ma'am. Because my lord, a small error, my lord. So.
So payment of this 25,000 was already dispensed with, right?
Yes, my lord. That date
You
was not disposed, my lord, but
permitted to be
proceeding
filed.
time was-
It is recorded in the last order that require, of course, your submission, requirement of payment of 25,000 has been dispensed with.
Yes,
By what order it has been dispensed with?
This order, ma'am. That is, I can
No,
file
no,
the
this order does not, this order says that further orders in the IA.
Appropriate bench of hearing was there. This is not dispensation.
The 25th, the Honorable Court has directed me to file the affidavit. You don't have
It's
to pay.
allowed to file the affidavit,
Not
but
pay-
it,
not
the fine is not dispensed.
Cost, it has to be adjudicated upon.
Yes, madam. That therefore, my lord,
There is no order.
therefore the IA
to-
comes for your lordship. Ma'am. That day there was paucity of time, but the court allowed me to, because I had prayed, my lord, and I showcased that this had happened. The court had allowed me to file the affidavit with the affidavit, and the court had
But
directed.
cost you have to pay.
No, my lord, I had that. That is why the IA has filed. No, my lord. That cost I will not. I have that to dispense the cost. So he has allowed me to file, man, on the last occasion. But last time, paucity of time was there.
Where was the order for paying you the cost in the main writ petition?
Petition was filed by 8/5. 8/5/2026.
If you not file the
That was filed
8/5,
with
then there is a it paid 20.
What was that order? 24/4.
Yes, 24/4. It was 24/4.
The said affidavit permissible to be filed on payment of 25,000 before the registration.
Exactly, ma'am. So what happened, my lord? I had filed it, but unfortunately, my lord, because of the defect, it got stayed. I couldn't file it properly. And then, my lord.
But on the next date, it is said that you will be permitted to file on payment of
I filed
25,000.
the IA also. I filed the IA, but still, my lord, for abundant caution, I filed my IA because IA is the right way. Then, my lord, I filed the IA, putting on record, my lord, why I couldn't file it. And then, my lord, on the last date, my lord, the Honorable Court, because there was paucity of time, Honorable Court heard the matter and just allowed me to file the affidavit without paying the cost. Because, my lord, it's too much, my lord. 225K, my lord, on the director. Because,
Achha, this is for recalling of the order. Go to the appropriate bench of Justice Nair.
Then, my lord will direct it there, my lord. Up to your lordship.
It was directed to.
Because he has given the order. And I, being a junior, cannot again recall. Okay. You move it before Justice Nair.
Can direct it.
Yes, I'll direct for listing the matter before Nair. You'll heard Mr. A. Fukan, learned counsel for the applicant, and Mr.
M.A. Chansari.
M.A. Chansari, learned counsel for the respondents. The present IA is filed by the applicant for recalling of the order dated 24/4/2026 and as well as 14/5/2026 by which, no, 24/4/2026 by which the respondent, by which the respondent number
2.
Respondent number 2 was directed to file the affidavit by 8/5.
Yes.
By 8/5/2026. And on failure to file the same on that day, by that day, an amount of rupees 25,000 was directed to be imposed upon the respondent. No, it exactly no. 8-5, huh? On or before 8-5. And in case the affidavit is not filed by that date, the same would be allowed to be filed on a subsequent date on payment of rupees 25,000 as cost. It is further prayed in the said IA that order dated 14/5/2026 be also be recalled, by which this court had allowed filing of the affidavit by respondent number 2. No. On payment of rupees 25,000 before the registry. He was permitted to file the affidavit on payment on a subsequent date beyond 8-5. By Justice Ete.
That's the main case.
That was,
IA, my lord, I was allowed to file without.
By Justice Ete in the main case. Thereafter, you have prayed for recalling of those two orders only.
I have prayed for recalling of the 25,000, my lord.
And 14-5.
Yes, my lord. And my lord, the IA has been, the last order has been passed by Mr. Majumdar. I was
So and so, huh? The petitioner submits, the applicant submits that the said affidavit was filed in time, but there was some defect in the affidavit.
No, they have not filed, my
No, we have withdrawn it, my lord. We have withdrawn, we had filed, we had withdrawn it.
It was filed, it was withdrawn,
Withdrawn.
was filed, but there was a defect found by the office of this court, and the same was withdrawn by the applicant. And by that time, the date, the date meant for filing the affidavit had elapsed. 8-5, right? This court, by the last order, dated 22/5/2026, allowed the applicant to file the affidavit on or before 1/6/2026. Without interfering with the order of payment of cost. For the interest of in the above facts and circumstances, it is therefore appropriate to place this I before the appropriate court. Within bracket, Deva, Honorable Justice, UK Nair. Registry to do the needful. Okay?
How the IA is to implicate opposite party number 7 as student number 7.
Why? Necessary party?
My lord, here, during the pendency of this matter, the matter was referred to mediation. The matter was.
No, iron is not disposed of. It will be placed before the appropriate court. Yes.
During the pendency of this matter, the matter was referred to mediation center to settle the issue. So between the parties, during the course of the mediation, it has come to notice of the applicant that like her husband also married another woman. So therefore, as per the last order of this honorable court, there is direction to implicate the respondent number opposite party number 7 as respondent number 7.
Okay. Heard Mr. T. Vapangla, learned counsel for the applicant. This is an application for implement of
Opposite party number 7.
Implement of the applicant, oh no, implement of the applicant, no,
Opposite party
implement
number
of Miss Srimati Mosumi Saikia.
My lord. Page 6, my lord.
Srimati Mosumi Saikia, the second wife of the petitioner.
Not sure whether it's the first or second wife, my lord.
Uh-huh.
So, not confirmed whether it's
Oh,
the
acha,
first,
acha.
yes.
Miss Srimati Mosumi Saikia as party respondent number 7 in the connected writ petition. It is stated by the counsel appearing for the applicant that applicant petitioner, right?
My lord.
Applicant petitioner, that the matter was sent for mediation, and during the proceedings before the mediation center, the applicant came to know that her husband,
That husband.
late husband, he died, that her husband who died had married Srimati Mosumi Saikia. And since the instant matter relates to family pension,
My lord.
family pension, the applicant stroke petitioner prays that said Mosumi Saikia be impleaded as a party respondent. In the said facts and circumstances, this court therefore allows the impleadment prayed for by the applicant petitioner and further directs that the petitioner would file an amended cause title and the resultant correction would be made in the CIS by the registry.
Accordingly, steps will
The I is disposed of.
steps will be taken accordingly.
Step you will take, first let her be impleaded, then you will take steps. Writ petitioner, dear, list this matter. In view of the impleadment application being allowed, and in pursuant to the in pursuant to the correction made in the CIS, list this matter. CIS, the registry to list the matter for admission. No idea. This I is for what? None appears on call for the, yes, Mr. You're there in the matter. This is for amendment of the writ petition.
Lord.
They will file a amended writ petition by withdrawing this or what?
Better to withdraw this matter, my lord, they have to challenge their order, which was not, but is enclosed in the manner of the IA.
Okay, they are not there. Let me see what they say. None appears on call for the applicant. Place this matter again on
Next week, anything?
10th of June. Mr. A.R. Bhuiyan appears.
Lordship.
He comes otherwise.
I have seen, my lord, is, today is true. Party.
Party? Very good. Let him enjoy this day. Let him enjoy this day.
Lordship.
Yes.
Obliged.
Yes. 48. Yes.
Said Lordship, no steps till date, Lordship. They have to take, it is, but, no, okay, it is there, but we have not received any instruction till yes, Lordship.
Number 4 only they have taken steps.
Lordship, according to the last order, they have already taken the notice.
Yes, we have not yet,
You give her the
received
extra
any
copies.
instruction.
Okay. Now, heard Miss
K. Bhattacharya.
K. Bhattacharya, learned counsel for the petitioner, and Miss M. Bhattacharya, learned government additional senior government advocate. The
4 actually the main party, Lordship.
Acha. So 4 not served,
As per laws of
delivered. By tracking the postal consignments, it was delivered. Let's see. It is seen by the office note that notice upon respondent number 4 is served, and service was detected by tracking the speed post consignment details. However, there is no representation on behalf of respondent number 4. Ms. M. Bhattacharya appears for respondent number 1 and 2, right?
Yes.
And what about 3, State Level Recruitment Commission? Can you appear?
No, I can't appear.
3, there is no
If
service,
the
there are no
Secretary of
steps.
Grade 3.
Oh no, somebody appears for SLRC.
Yes, your lordship, last.
B.
B.
Chaudhary.
Chaudhary, yeah.
Occasion, he appeared.
As far as, no, as far as service of
Chaudhary,
notice,
yes, sir.
as
I
far
think-
as far as other respondents are concerned, the respective respective standing councils.
Standing council, this has to be reflected, lordship.
Acha,
SC,
standing-
SLRC.
Acha, respective standing councils has appeared on the last occasion. As accordingly list this matter on when date? When? List this matter on 24th of June, 2026. It is further directed that the name of Standing Council of SLRC be reflected in the cause list. Oh, you are waiting for this matter now since long, by God. This is 4 o'clock. Yes. But respondents are not served, the 3, 4, and 7. Or delivered, but they are not represented. Right. So what about respondent, Mr. Saikia and Mr.
I am for
Rahman?
respondent 5 and 6, Lordship.
1 and 2, P. Saikia. 5 and 6, you, Mr. Rahman.
Yes, Lordship.
And what about other principal investigator?
Yes, respondent number 7.
7?
Respondent number 3, 4, 7. So steps has been taken.
3, 4, 7, right?
3, 4, 7. In the
3,
last
4,
order,
7 is otherwise delivered.
yeah, in the last order, actually it was instructed to, directed to serve the copies and notices. So I have taken the steps, 3, 4, and 7.
No, this service notice, or this service report was of 2/6/2026. It's only few days back.
Yes.
So let us wait. They will represent themselves, I think, by way of some councils.
Lordship, it is-
I had to keep you waiting for so long, but then this respondents are not, they are served, but they are not represented. So we can await for some more time. There will be representation. It's not that the report was of long, is long back.
They have received the report on 13th of May. 13th May, they have received the.
But then the office note shows 2/6/2026. Case taken up before the Lavajima court.
Lavajima.
Huh.
But the-
Perusal of the recent office note dated 1/6 shows that notice was issued. Huh. Neither ID cards. However, by tracking the consignment details, it was found that notice was delivered. Okay, on
They
2/6.
Delivered on 13th of May. I have
Acha,
gone through
that
the,
date is not given here.
I have gone through the track record.
But let the respondents be represented. Right.
Lordship, actually, it is a matter of my livelihood. I have
Hmm.
not received my salary for last 26 months. So it is very difficult to run my family. That's why it is urgent.
Yes, I understand. Who has to pay? Finance is made a party.
Yeah,
No,
state government is making the finance.
3 and 4, they are the necessary party, madam. They have given appointment and salary have to paid by them only, madam.
Director Assam Science Technology and Head
That
Science and
scheme, madam, on the basis of that scheme he has appointed.
so the money has to be paid by them.
Them, madam. Madam, since madam notice, they have only delivered report is there, madam, petitioner may take dusty also. Because he said that the matter is very urgent.
No, why I'm worried is only few days back it is served.
My lord. So
But then he's saying that it was in the month of May.
May 13th.
because my lord, without them, my lord, we cannot do anything. Therefore. they have
Because
to
money has to be paid by
that
them.
Them, my lord.
There is explicit order of the government also to pay my pending salaries. But they are not.
You are still working.
Yeah, I'm still working.
You are not paid salary for how many months?
From April 2024 till date.
April 24.
Yeah.
Why they have not paid your salary?
Actually, the respondent number 7 is the principal investigator who is responsible for disbursing my salary. But he did not submit the utilization certificate and statement of expenditure in proper format. So which is found from the letter of the director estate. So he is asking to submit the utilization certificate of the last sanction in the proper format. He did not actually committed that.
He did not submit those
Yeah.
utilization certificate and
that's
the
right.
expenditures incurred.
Some unauthorized absent.
Lordship, actually.
There was some allegation against you.
No, actually, I was in leave for 2 months because of my mother's health issue and my personal issue. So for that, he actually said that, so your leave is unauthorized. So that matter is pending till date.
Your leave was not granted.
Not granted. He asked me, he actually called me for clarification to show cause why actually my leave was not, has not been unauthorized. I have replied, duly replied the show cause, but even though he is pending my leave matter, and he is saying that the grant has not actually sanctioned from the director estate, so I cannot actually disburse your salary. This is the only reason why I am not getting the salary.
Current salary also you're not getting.
Yeah, I'm not getting. That's why I approached the secretary.
Some DP was held against you.
No,
No.
nothing else. Only that leave matter is there. Only that.
Yes, Mr. Rahman.
As per the last order, Lordship go through the order, it is ordered why he has been paid, Lordship. Actually, he was appointed in a project, my lord, that was discontinued, Lordship. Lordship, in the last order of this honorable court passed on for 5 years, Lordship, this is recorded, Lordship. My lord, Esther has to reply actually, my lord.
That is the thing, Lordship. Actually, the
I'll just see the last order.
The project was discontinued, Lordship, actually.
this is not correct.
As
As per director's letter, the closure of the project is not.
As per your next, I am submitting.
It was actually said by the council, but on record is not true.
No, but then he was okay. He was taken over with regard to some project, but he was working in the Center for Radio Astronomy as a research scholar. Right.
Actually, I was initially appointed as a project fellow. Then after recommended me for research fellow. Then after they appoint me, they actually by the proposal, promotional proposal.
Acha, whatever it is, you please serve dusty service on respond number 3 and 4 and 7.
That would be better, Lordship.
Even principal investigator is not in represented
Dusty service means
by hand.
Representing myself. 3 and 4.
3, 4 and 7 investigating officer.
Yeah, I can do that. I can do that. I can actually place in the office itself.
Okay.
Cotton University.
Heard Mr. Dr. Manavendra Lohkar, petitioner in person. Also heard Mr. P. Pending counsel for Cotton University has also made a party, right?
Yes, Lordship.
Huh?
I am representing now, my lord, for 5 and 6, Lordship.
5 and 6 Cotton University.
Oh, acha.
Again.
You are for 5 and 6.
Yes, Lordship.
Okay. Also heard Mr.
H. Rahman.
H. Rahman, learned counsel for
Spot
Cotton
number 5 and 6.
for 5 and 6, and Mr. P. Sakya for respondent number 1 and 2. It is reflected in the order of the Lawajima court that service of notice was complete in respect of respondent number 3, 4, and 7. And the said service was detected only by way of tracking the consignment details. Full stop. Otherwise, there was no report of, otherwise, neither AD card nor unserved notice has been received in respect of 3, 4, and 7. As such, the learned petitioner the petitioner in person is instructed to serve the notice upon respondent number 3, 4, and 7 by way. As such, the petitioner in person had submitted that he may be allowed to serve the notice upon respondent number 3, 4, and 7 by Dusty, and that he would also be filing an affidavit to that effect after service being effected. Prayer is allowed. When can you come again? You stay where?
I'm staying here in Gauhati.
Acha. List this matter again on after vacation or before. He's not getting his salary. So list this matter on 19th of June. You please give them, and even if they do not come, then we will proceed against without them. Right? Yes. 60. Yes, Mr. Chomo, you were
Pilot,
waiting for
this matter,
Ah.
why it has taken time, I have already in last occasion, I have submitted before the coordinate branch of this court, Milan. This, the promotional aspect of the petitioner has been placed before the DPC, it has considered. When the DPC considered, it was on 7th March 2026. In the meantime, the election code of conduct was declared, and the chairman of the ASTC resigned because he participated in an election. So the ASTC board is defunct now. So no one there is there to take a decision, because it has to take an approval from the board. Ultimate promotional order will be signed by the managing director, but it has to come routed through the board. So it may take time, 2-3 weeks more, because today the ministry has been formed in full form. So to bring everything on into order, maybe 3 weeks or 4 weeks or maybe 2 weeks even. So we have to wait. This is
You are an employee of the ASTC.
ASTC.
Now ASTC is no longer there.
No, ASTC is there. The board is defunct because of the resignation of the chairman.
Chairman.
Because chairman is a political person. So he resigned, so the board is defunct. So it has to be reconstituted.
Chairman will be appointed again, some other chairman.
Yes.
Okay, so let us wait for 2-3 weeks.
And new notification gazette notification has to come from the governor for constituting the board. That is a technical aspect. We cannot help on this.
Okay, heard Mr. M. Ahmed, learned counsel for
Yes, of course.
heard Mr. M. Ahmed, learned counsel for the petitioner, and Dr. A. Chomo, learned standing counsel for ASTC. Mr. Chomo submits that the case of the petitioner, that is his promotion
Yes.
from the post of
To the post of general manager.
to the post of general manager has to be placed before the
No,
DPC.
it was placed before the DPC.
Oh, it was already placed.
Already placed DPC on 7th March 26, which was considered in affirmative. But
Was placed before the DPC on 7th of March 2026, and it was decided that the promotion should be granted to the petitioner. But the chairman of the ASTC had resigned from the post in the meantime, and due to the code of conduct, due to the election,
code of conduct.
due to the code of conduct imposed,
Yes, election code of conduct.
election code of conduct imposed for the election, which was held in the month of April, the board had become defunct. Board constituted by the ASTC.
No, board constituted by the government
Board constituted by the government.
has become in.
No, board is in respect of which.
ASTC is a corporation. The board which controls the corporation is to be constituted by the government.
And the chairman of the board had resigned.
Yes, that is
Other
why.
papers are there, only chairman
But
has to be.
when chairman resigns, the board goes.
And the board constituted by the government had become defunct with the resignation of the chairman. As such, a prayer is made for adjourning the matter for a few weeks so that the board is reconstituted.
After the vacation.
Okay. For some time, Lydia, so that the board is reconstituted by the government and the case of the petitioner could be taken up.
Madam.
Prayer is allowed. List this matter on 21st of July. or 22nd? 22nd of July, Wednesday.
22nd. Obliged.
I is for what?
My lord, this item 61 and 62, my lord, these
Hmm.
two IAs have been filed for typographical error. My
Acha.
lord, you remember your lordship has passed two orders, one in a writ petition, one in a review application.
What happened? Something is, some,
Typographical errors are there in page 8. I have given a detailed explanation, my lord.
huh.
And if required, my lord, I can assist the court master, then it can be pointed out.
No, it's okay. 8, page 8.
Page 8, para 2.
Huh.
If your lordship sees 2A, 2A,
Hmm.
and as noticed in para 3 of the said order, the writ petition number was erroneously mentioned as WPC 9294 of 2024 instead of WPC 9299 of 2024.
Hmm.
That can be reflected at page 13, my lord.
Hmm. Then?
Second is that as noticed in para 4 of the said order, date of disposal of the
Only 3 mistakes, right?
4, my lord. Next page also.
Hmm.
D. This 4 mistakes.
Okay.
That those typographical errors, it can be rectified now.
Heard, Mr.
K. Mohammed.
K. Mohammed, learned counsel for the applicant, and Mr. D. Bora, learned government advocate. By this interlocutory application, the petitioner has sought for correction of the clerical mistake that had appeared in the judgment and order dated 12/5/2026, passed in WPC number 5066 of 2016. The petitioner has prayed that at 4 places, clerical mistakes, typographical mistakes has been noticed. And they are in paragraph number 3 of the said judgment and order. The writ petition number was wrongly reflected as 9294 of 2004, whereas it should have been 9299 of 2004. Secondly, in paragraph 4 of the said order, the date of disposal of review application. What review application? This was a review only?
No, not this review, my lord. There was one
Another review.
earlier.
That day I forgot the facts. Date of disposal of earlier review application was wrongly mentioned as 31/5/2005, whereas it should have been 31/1/2005. There are so many dates now while dictating. I think those mistakes occur. Even in Supreme Court, I've seen corrigendum comes.
Yes.
Happens. Thirdly, in paragraph 8 of the said judgment and order, the date by which a communication was given by, the date of the letter, the date of the letter by which a communication was given by Deputy Commissioner Dorong to Commissioner and Secretary Government of Assam was wrongly mentioned as 22/5/2016, whereas it should have been 22/5/2015.
My lord, in fact, the wording is exactly this one. 22nd of May 2000.
Okay.
In
So,
fact,
hetu
in
kora
page
diya.
16 it is.
22nd of May 2016, whereas it should have been 22nd of May 2015. And lastly, in paragraph 9 of the said order, the order of the court was mistakenly mentioned as 27/1/2014, whereas it should have been 21/7/2014. It is checked and it is found that these typographical mistakes had in fact occurred in the said judgment and order. Accordingly, the date mentioned in paragraph 3 Oh, the number of the writ petition mentioned in paragraph 3 will be read as writ petition number 9299 of 2004, comma, in paragraph 3, the date of disposal of earlier review application should be read as 31/1/2005.
That is para 4, my lord.
Paragraph 4. In paragraph 4, koso to? 4.
Three then.
Comma. In paragraph 8, the date was wrongly mentioned. The date should be read as the date of the letter. Should be read as 22nd of May 2015. And in paragraph 9, the order of the court should be read as 21/7/2014. This order will become a part of the order of the aforesaid judgment and order dated 12/5/2026. The I is disposed of.
Same, my lord, in respect of item number 62 also.
62 also.
That is in respect of that review order was passed,
Mm.
my lord.
62
There also
to Jackson?
three, same.
How many mistakes there?
Three, my lord.
Same.
Same, matlab, the equal lordship is at para 2. Same, para 3, 4 and 8, same mistake.
3, 4 and 8. There are 3 here.
There are 3.
এইটো আগৰখিনি একে একে থাকিব হা ইন ইনষ্টেণ্ট এপ্লিকেশ্যন হেজ বিন ফাইল ফৰ এই একে একে থাকিব বাছ সেই লাষ্টৰটো কৰা দি সেইখিনিও একে থাকিব খালি এই যে নাম্বাৰিং দিছোঁ ইন পেৰাগ্ৰাফ 3 দ্য ৰিট পিটিশ্যন নম্বৰ এইটো ছেইম 1 নম্বৰটো একে
All are same.
all are same.
Yes.
Same di diba. But one is missing.
Yes, that is only in respect of that petition that order was.
Which paragraph?
That was in para 9.
Para 9 to dokar ne? Para 3, 4, 8.
Yes.
Same. Yes. I is disposed of.
And be clear.
So who knows? Yes. Hearing matter. Arun Kumar Mohanto. But it's 4:30, so I cannot take up hearing and then I'll have to write again. Yeah, on 11th. As prayed for by the learned counsel appearing for the petitioner. Inconclusive hearing. By this court.
50-51 is it?
Oh, 50-51. 63 to key. Oh, acha. Oh, acha. 50-51.
Yes.
Okay. As prayed for by the learned counsels appearing for the petitioner, list this matter on 11th, you said?
Yes, yes.
11th of June. You make a prayer, you make a mention in the morning, I'll remember.
Yes.
11th of June. Okay. Oh, pray. Oh, have a good weekend.